matter. And next week, any date mean.
Next week.
Obvious.
Milord, I understand Lordship is having the other responsibility also. I have a matter item number 4. If it is taken up, it will take some time. How is Lordship like to?
We're actually in the middle of a couple of parthas.
Okay.
One, I think Mr. Rawal is there.
Yes, yes.
So,
Yes, my friend Rawal is also there.
so we have done some amount of hearing.
Yes.
Is the other side?
In that case,
Yes,
Milord,
other side is here. We've informed them also, my lord. And
they
they have not filed. We have brought everything on record. We have made application on the
Then
RTA.
we'll take it up.
Lordship,
Let them be around.
I'm here. Great.
Milord, item number 4,
Yes.
there is some amount of urgency for us also. Can we pray for 2nd of December, Milord?
2nd of December.
Yes.
There are already 68 cases fixed.
It's also.
Remember last week.
4th is available. 4th of
What
December.
about that?
4th of December.
Yes.
Right.
Deeply right.
4th of December, item number 4, on a request made by Mr. K.N. Chaudhary, senior counsel appearing for the petitioners.
No, I have not informed the other side. Inform them. They will not.
Take it that
We have already. We'll inform Milord.
Fourth.
Under the peculiar situation I mentioned, otherwise I came prepared because I came to know that Lordship
We are
is sitting
also
in that
aware because,
commission also, therefore deeply right.
May please, Lordship. Lordship, I beg to mention for listing of a read in the next week for admission column. So pleadings are complete. Petitioner was removed from service. He was
let it come in December.
Lordship. He was also reinstated in service, but despite of in the year 2019, but he was not allowed to join in service, and he is retiring in the month of April, Lordship, 26. Since 2019, though he was reinstated,
27th November.
Can it be next week if possible, Lordship? Emergency.
Next week we are unable to give. We can give you. You can matter can be listed, but we don't know whether your matter will be heard, taken up or heard.
Let me take a chance, Lordship. Let me take a chance, Lordship, if possible, Lordship.
Next week.
Yes, Lordship.
Next week.
On 13th, Lordship, if possible, Lordship.
Like 13th.
Deeply, Lordship.
But the problem is the
Yes,
comes as a
yes,
fixed
yes.
item.
Yes, Lordship.
So we can't give you a guarantee that
Yeah,
it will be taken up.
that is true, Lordship.
Yeah.
But let me take a chance. It is a small matter. Others, they have already reinstated me. Only the direction to allow me to join. They have not allowed me to join.
May I please, Lordship, bring for listing of this IA, Lordship, on Monday, Lordship, for correction of order, Lordship. Monday, Lordship.
Let it be on 12th.
Always, Lordship.
My Lordship, to mention 2 matters for admission, Lordship, regulation of services matter, Lordship, next week or any date, the November,
4th
Lordship.
December,
So,
4th or 9th.
so last week of November, if possible.
4th or 9th.
Lordship.
4th.
Lordship, similar prayer. I pray for listing of it to
Then
read
9th,
petition.
9th December.
Obliged, Lordship.
Lordship, I beg to mention a writ petition for listing
For
for admission by next week.
not next week. What is the urgency?
It is the matter of challenging the court, my lord.
Huh?
Urgent order necessary.
Why? What is the urgency? For what purpose?
Mainly the petitioner didn't get the enquiry report till now.
4th of December.
Okay, ma'am.
Yes, please, Lord. With the consent of the other side, I beg to mention item number 18 of today's list, my lord. Actually, my senior and is out of station, my lord. So I'm playing this matter.
18.
18, my
Lordship,
lord.
I am for the other side, Lordship. This is otherwise a part third matter. So I am praying that a short date may be given, preferably maybe, if possible, next Thursday, Lordship.
Next Thursday.
If possible, Lordship. Lordship, at heard the matter at
All right,
11th.
13th.
Deeply obliged.
Item 18 on 13th.
May I please, your lordship?
Request made on behalf of the respondent counsel.
Please, your lordship. I beg to mention for listing of a selection and appointment matter, lordship.
For admission orders.
For admission.
For admission. 8th of December.
But we can be next week.
No, 8th December.
Obliged. Lordship, may I please to mention for listing of a matter for admission?
8th December.
It's. Okay.
May I please, Your Lordship, I beg to mention for listing of a writ petition for motion, Lordship, tomorrow, Lordship.
Writ petition, why is it not
Lordship,
listed?
the insolvency proceedings has been initiated against the petitioner and the next date before the NCLT is on Monday, Lordship.
To insolvency, what has the writ court got to do with it? You have to file your applications.
Lordship, we have
Okay.
preferred an application there regarding the maintainability of the insolvency proceeding, but that has not been heard and no order has been passed against that. That's why we are before the appropriate writ court, Lordship.
All right, tomorrow, let us.
Much obliged.
Wait, please, Lordship. And Lordship, contempt case list for orders. List for orders.
For
Orders.
orders, all right, 8th of December.
Lordship, this matter may come up tomorrow, Lordship. Similar matter is there, Lordship.
Motion,
Motion, Lordship.
motion matters.
Motion matter, Lordship.
Itu masuk apa? Mari dulu.
May I please, Your Lordship? Your Lordship, Dr. Saraf is on legs. May the matter be passed over for time being?
We'll be taking up a partner matter today, so it may not be possible. We will fix another date.
Your Lordship, may I see the calendar and let the court master know about
We will have it in end of November or December,
Your
early December.
Your Lordship?
Much obliged.
Yes. Yeah, what do you do? Partners.
Wait, please, sir. Lord, we had applied under one of the petitioner, applied under RTI. And he has got documents. They have forwarded even the opinions of the learned standing counsel, learned advocate general that I had referred to, my lord. And we have placed it on record by way of a separate affidavit.
You have brought it.
I have brought it on record. The lordship, please, has this additional affidavit. Is there? It was filed on Monday, my lord. I have an affirmed copy, my lord. I have the filing proof also. We have solved the other side. This is an affirmed copy, my lord. It starts from page number 551.
Five 51.
551. This petitioner number 599.
No, it has not come.
Where is your filing?
Mine looks good.
We filed it on 311.
You can ask AOR to call it on record.
Yes, for the address. Yes.
Yes.
In the meantime, if I may invite your lordship's attention, Mala, para 1 he says is 599. Then Mala, kindly oblige me and have para 2. For the first line, Mala, it should be BEGS, not BAGS. Mala.
Where?
The deponent
Uh.
begs to. Typo error. To state that during course of the arguments on the last date of hearing before, it was submitted with a communication dated 3/4/23. A committee was constituted by the government of Assam comprising so-and-so, 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 and other members for the purpose of examining the judgment rendered by the Honorable Supreme Court in SLP number so-and-so with transport case number so-and-so in the matter of Barul Islam versus Indian Medical Association to submit a report along with suggestion or recommendation within period of 2 weeks. The humble deponent begs to state that he had procured under RTI 2005 official minutes of the meetings conveyed by the said committee on 22/6, 12/7 and 27/7/23, together with related communications from the Medical Education Research Department, hereinafter referred to as MERD, forwarding Supreme Court order, legal opinion for necessary action by Health and Family Welfare. Then, my lord, please go with me to page number 557. Annexure A1. The Secretary to the Government of Assam, Malot, writes a letter to the Director of Medical Education. If I'm with my Lords, Malot, at 557. This is dated 16th February 2023. Regarding SLP number so and so, with reference to the subject cited above, I am directed to forward a copy of the Supreme Court judgment order on 24/1/23 in SLP civil number 32592, 32593 of 2015, Barul Islam and others versus Indian Medical Association and others for information, and please mark and request you to take necessary action accordingly. Then Malot over the page at 558. Malot, on 21st of May, they take the opinion, Malot.
But why have you, how have you have access to this legal?
Well, they sent it to us.
But
Well, I know, Malot.
I don't think it is proper.
Very well, but
This is an opinion between the lawyer and the counsel.
well, since it came with the papers, if I don't place the complete, Malot, but I'll not even read it, Malot. Please go to Malot. Page 562. This is one of the secretary again writing to the joint secretary. Reference 23.5. With reference to the subject cited above, I am directed to herewith forward copy. So when this letter came, they sent it to us, Malot. Along with legal opinion, so and so, it appears that the judgment is for job functions. Please mark this Malot paragraph at 562. It appears that the judgment is for job functions of the rural health practitioners, RHP community health officers, and the matter of appointment and the job responsibilities of RHP CHOs are dealt in the Health and Family Welfare Department. As such, the legal opinion of the Standing Council and Supreme Court order dates so and so are forwarded herewith for compliance of the Honorable Court's direction under Health and Family Welfare Department. So this was their view. Then Malot comes 26 July 2023. Over the page at 564, annexure A5. After discussion, the following observations were made. May I please, Malot, the second paragraph after the names. A meeting was held to discuss about implementation of judgment of the Honorable Supreme Court with transferred case number so and so. The Secretary Health and Family Welfare Department welcome all members so and so and brief the detailed purpose of the meeting as to ascertain which of the demands of the community health professionals, please mark Malot, rural health practitioners can be fulfilled and requested all to present to offer their views. After discussion, the following observations were made. Although as stated in para 25(4) of the Honorable Supreme Court judgment dated 24/1/23, community health professionals who would practice as allopathic practitioners in the manner as they were permitted in practice under the Assam Act in rural areas of the state of Assam, Director of Medical Education Assam stated that allowing community health officers, rural health practitioners to practice as allopathic practitioners would be against the ethics of the National Medical Commission. Moreover, they do not have the requisite registration under the NMC nor eligible qualifications as the study course of both the posts are different. However, the Director of Medical Education Assam suggested that the government may think of post creation for providing them permanent employment in primary health center, rural sub-centers with promotional avenues as they are presently employed under the National Health Mission contractually. Controller of Examination suggested of creating a separate council which will provide them separate registration numbers instead of agreeing to the demand of providing them with registration numbers of a registered allopathic practitioners, which will be controversial as they cannot get registered under the NMC Act. However, the Executive Director, National Health Mission had informed that creation of a separate council will only help government to keep a head count of RHP and that providing them with a separate registration number will only fulfill the urge of them as practicing as allopathic doctors, which might be contentious. However, he suggested that promotion to existing RSPs may be provided by creating senior post. Joint Secretary Health and Family Welfare Department suggested that of their other demands, nomenclature, redesignation, and streamlining their role and responsibilities in sub-areas may be looked upon by the government in order to demarcate them from the nurses who also fall under the community health professional. Well, your lordship may permit me to pause here. I had mentioned during the course of my argument that CHOs are nurses. They undergo 6 months course. They can be from commerce. They can be from BSc. Unlike us who have undergone a course of 3.5 years and 6 months of internship. So they are also aware that these two, though come under the head of CHO, because that is the fallout of the judgment, if I may say so, my lord. They are aware that the duties, the qualifications, the courses undergone are separate. Then they say further Secretary Health and Family Department suggested to go by and stick to NMC Act and stated that decisions are to be made after threadbare discussion without violating the guidelines of the said act, and therefore in view of the above, another meeting has been scheduled on 12/7 in order to come to conclusion. So Mala, it records suggestion, the decision remained inconclusive is my reading, Mala. Please see the next one at 566.
This meeting was held on
This was held, Malad, on
22/6.
just give me a moment, Malad. It was held on yes, Malad, 22/6. And the minutes are signed on 27/6. Then the next meeting, Malad, is held on Malad 12/7, I believe. Yes, Malad. The Lordship will find the date at the top of the page, 566.
Yes.
Fourth line, 12/7. In continuation of the discussion on implementation of a judgment of the Honorable Supreme Court of India, number so-and-so, in so-and-so, a second meeting was held under the chairmanship of so-and-so and the chamber of so-and-so. The Secretary, Health and Family Welfare Department, I may skip that. After careful consideration of the matter, the Secretary, Health and Family Welfare Department was of the opinion that the demand of the Community Health Officer Association of redesignation from Community Health Officer to Additional Medical Officer as per Subhashish Bakshi versus State of West Bengal case may not be entertained. As per the suggestion put forth by the Controller of Examination, Office of the Director of Medical Education Assam and Vice Principal GMCH, the roles and responsibilities of community health professionals are to be kept in line with Assam Community Health Professional Registration and Competency Act 2015. As decided by the committee members, the community health are required to follow clinical competencies and as well as public health and general competencies as mentioned under the Assam Act of 2015. The committee had discussed also about creation of a separate registration council. Under this council, community health professionals will be provided a license to practice subject to rules and regulations as per the Assam Community Health Registration and Competency Act 2015. The areas of jurisdiction of the community health professional shall be at sub-center level and any other places may be determined by the government from time to time. Permanent employees post cannot be assured to community health officers. However, they are to continue working contractually with fixed pay and increment as per existing procedure. Consequently, the Joint Secretary Health and Family Welfare suggested that she, along with the Director of Medical Education Assam, will have discussion on framing of skeleton of the rules to be made against the aforesaid Act 2015. After finalizing the skeleton, the committee members will be sent a copy for their views and comments regarding the same. Lastly, in view of the above, another meeting has been scheduled on 27/7/2023. That is at page 568. So, Malod, they discussed this again in my humble submission.
What is this judgment of Subhashish Bakshi?
Malod, Subhashish Bakshi is, Malod, if your lordship see page number, Malod, if that compilation, I have placed it at E, running page 143. But a similar problem had happened in the state of West Bengal. And the Honorable Supreme Court holds, well, at two stages such problem had happened. Well, one was in the case, if your lordship will recollect, well, homeopathic doctors around the country were prescribing allopathic medicines. The matter got settled. It came from a judgment of the Rajasthan High Court, and the Honorable Supreme Court said that yes, they are entitled to do so. This is one such similar matter, my lord. 143, if your lordship please sees. It's a very short judgment.
Yes.
Lordship may, for the purpose of facts, my lord,
Hmm.
oblige me and have page 144, para 2. In one paragraph, the entire facts are stated, my lord. The long-winded facts. Do my lords have it? Or that thick compilation of judgments?
This one?
Yes, my lord.
No.
It says index of judgments, my lord.
We have the index.
But running page number, my lord. I'm so sorry. Perhaps, my lord, earlier your lordships had marked it.
Yes, perhaps 143.
But that was probably, my lord, in June or something, my lord, when I concluded my arguments in 144. The judgment starts at 143.
Yes.
The long-winded facts of this case read as follows. That about 337 persons, including the appellants, had completed diploma course of community medical service in duly recognized institutions in the state of West Bengal and were posted in different parts of the state by the government of West Bengal. On 15/10/1980, with a notification number so and so, the government of West Bengal made an amendment in the statute of the state medical faculty by introducing Article 6F under Part B, which reads verbatim as under. Students who will undergo and complete requisite course of studies in medicine, medical science as defined and detailed in the schedule to this article and hereinafter called as the regulations for the diploma course in community medical services in medical institutions duly recognized by the state medical faculty of West Bengal shall be admitted into examinations in the subject laid down in the said regulations, and the students passing the examination shall be granted diploma with the abbreviation DIP CMS by the governing body of the aforesaid faculty. The governing body of the aforesaid faculty shall also maintain a register of such diploma holders with a view to regulating, supervising, and restricting their practice for the present. So, my lord, here it was by an act, in our case, state of Assam. There they did it by virtue of introduction of section Article 6F. The objective of the notification was A, to provide medical training to a group of personnel to man the health centers and subsidiary health centers. Emphasis is to be given on comprehensive health care of community, including promotive, preventive, and curative aspects. A candidate, after successfully completing courses of study, will act as team leader of various categories. Training in curative medicine is to be imparted in such a way that after completion of training, the trainees can treat common diseases among rural population, including communicable diseases, malnutrition, stage, snake bite, insecticidal poisoning, etc. Instructions on disease requiring sophisticated treatment not practicable in health centers will be restricted to the barest minimum. However, such candidates should learn to recognize signs and symptoms of more serious disease requiring special treatment at referral hospitals. My lord, akin to our duties, my lord, I had invited your lordship's attention, my lord, if your lordship will be pleased to recollect that certain medicines only we can prescribe, certain, my lord, diseases only we can identify and treat. The rest we have to refer it to the, my lord, the RMO. On 23/6/87, the government of West Bengal issued a corrigendum, and the diploma that was earlier known as Diploma in Medicine for Community Physicians was rechristened as Diploma in Community Medical Service. Apprehending that renaming would have detrimental effect on their rights, the appellants filed writ petition number 7052 of 1989 in the Calcutta High Court. The said writ petition was disposed of by the learned single judge on the assurance given by the government leader that the state was willing to award diploma in community medical service to the successful candidate. It was also assured by the state in the said petition that it would provide jobs to such candidates in accordance with the stated policy of the government. The learned single judge of the High Court made it clear that diploma holders will not have a right to private practice, and that part of the order was not challenged by the appellants at all, and entry in the register is only for the right to prescribe medicines and issue certificates. Aggrieved by the order of the learned single judge, the appellants preferred an appeal before the division bench of the Calcutta High Court. The division bench assured that the change in nomenclature would not affect appellants' right. The division bench reiterated that persons holding diploma and employed to man the health centers and subsidiary health centers would be competent to treat common diseases among rural population, including communicable disease, malnutrition states, snake bite, insecticidal poisoning, etc. Division bench also mentioned that the state government policy in providing jobs to such diploma holders. Upon this, the High Court opined that in light of clarifications made by and on behalf of the state medical faculty and the state, there should be no reason for the appellants to entertain any kind of apprehension with regard to their being able to perform functions and duties which they are entitled to do under the regulations as amended with a notification dated 15/10/1980 pertaining to the registration of names in the register of diploma holders. The High Court stated, register shall be prepared, will be maintained in accordance with and in terms of Statute 6F, and necessary formalities in that regard will be completed on or before 31/3. This judgment of the High Court was not complied with by the state. Contempt application was filed. By the time Director of Health Services West Bengal issued job description of community health service officers. While hearing contempt application on 23/11/1990, the High Court accepted the assurance given by the Secretary to the government in the Department of Family Welfare in presence of Secretary of Medical Faculty and the State Medical Council that the government would issue fresh instructions to the job description. Well, Lordship may skip all of that and go to para 6 at the bottom of the page, if your Lordships, my Lord, permit me. Well, I'm sorry, my Lord, the 4 lines above that, just 2 lines above class item G, it is also clarified by the High Court in the order that registration by the state medical faculty will authorize community health service officers to continue to discharge their duties as specified in the duty charge in the health centers, subsidiary health centers, as long as they are in service. Upon this high note, the first round of litigation before the Calcutta High Court was concluded. At this juncture, by virtue of the order of the High Court, the appellants had obtained right to treat common diseases among rural population, including communicable diseases, malnutrition states, snake bites, insecticidal poisoning, etc. But the grievance is that consequential right of issuing certificate of sickness or death prescription was taken away by notification dated 21/11/1990. It is also case of the appellant that item 17 of the said notification was cancelled, challenging the denial of consequential right to treat, such as the right to issue prescription or certificate of sickness or death. The second round of litigation was initiated.
The earlier judgment did not travel to Supreme Court.
No,
Of the
the earlier first round did not, the contempt round did not. Then, my Lord, if your Lordship sees at page, paragraph 9, aggrieved by this order of the learned single judge of the High Court, Bengal Medical Council, here, my Lord, it was the Assam branch of the Indian Medical Association which had filed the writ petition. Lordship recall that Barul Islam, where we were not made parties,
Yes.
and no relief was claimed against nullification of the, my Lord, degrees or diplomas that we had been granted during the operation of the act. There was no stay. My Lord, in fact, the state had, my Lord, one thing comes out from the bunch of papers, my Lord, that I produced along with my today's affidavit, that the state had, my Lord, very vehemently requested the Honorable Court that please make them as parties. There is no relief, please hear them. That comes out from one of the opinion, but that's only as a matter of fact. But it, my Lord, reinstates that the factual position that we were never heard. There was no relief to nullify any of our, my Lord, diplomas which were granted during pendency. As my Lord, I had indicated to your Lordships that, my Lord, we were creature of a scheme undertaken by the state pursuant to a legislation. We acted on it, gave, my Lord, our 3.5 years and 6 months internship, and were conferred diplomas. We were engaged. No private practice. Similarly, it is at that stage, my Lord, here in Calcutta, at the second stage, the Bengal Medical Council preferred an appeal before the division bench. The division bench allowed the appeal and set aside the decision of the learned single judge, but precisely on the ground that it is contrary to Indian Medical Council Act as it was then in force. The 2 main reasons given by the division bench to vacate the writ, they are that sine qua non for the application and operation of section 18 are satisfaction of the council that any particular qualification is sufficient guarantee for the requisite knowledge or skill for efficient medical practice, report to the effect that counsel to the government, directions by the government on acceptance of such report by notification in the official gazette. We do not think that in 1915 the council could in any way be satisfied as to the quality or merit of a course or qualification introduced in 1980. Well, here it's that Act of 25, which this was introduced by the Act of 2005. 2004, I'm sorry, and could report its satisfaction by some sort of divine prescience or foresight. Nor do we think that the government could by notification recognize or approve a course or certification or qualification in futuro or in vacuo in respect of a course or certificate which was not in existence at the date of notification. Relying on A.K. Sabhapati, Doctor versus State of Kerala, it was found that the person can practice in allopathic system of medicine in a state or in the country only if he possesses a recognized medical qualification, and since the appellants do not possess the required qualification, it was held that their names could not be included in the medical register. Thus, this appeal by special leave. So this is how the division bench held that they could not. Now, please see para 11. In this context, it is worthwhile to discuss Dr. Mukhtiar Chand versus State of Punjab. In this case, validity of notification issued by the state governments of Punjab and Rajasthan under Rule 2EE3 of the Drugs and Cosmetic Rules 1945, whereby governments declaring some Vaids, Hakims as person practicing modern medicines was challenged. Upholding the validity of the notification and the said rule, this court held that for the purpose of Drug Act, what is required is not qualification in modern scientific system of medicine, but a declaration by the state government that a person is practicing modern scientific system and that is registered in the medical register of the state. SCC page 593, para 32. In Mukhtiar Chand, this court also clarifies that there could be two registered for medical practitioners, that is Indian Medical Register and the State Medical Register. So I pause here. Here also there is a separate act, Assam Medical Register Act, which also provides a similar thing. As far as the state medical registers are concerned, the state government concerned, according to rules, will determine required qualification. While recognizing the rights of Vaids or Hakims to prescribe allopathic medicine, this court also took into account the fact that qualified allopathic doctors were not available in rural areas, and persons like Vaids, Hakims are catering to the medical needs of residents in such areas. Hence, the provision which allows them to practice modern medicine was found in public interest. In this context, Dr. Mukhtiar Chand holds that it is thus possible that in any state, the law relating to registration of practitioners of modern scientific medicine may enable a person to be enrolled on basis of qualification other than recognized medical qualification, which is a prerequisite only for being enrolled on the Indian Medical Register, but not for registration in a state medical register. Even the 1956 Act recognized medical qualification is sufficient for that purpose. That does not mean that it is indispensably essential. Persons holding recognized medical qualification cannot be denied registration in any state medical register, but the same cannot be insisted upon for registration in a state medical register. However, a person registered in state medical register cannot be enrolled on the Indian Medical Register unless he possesses recognized medical qualification. This follows from a combined reading of section 15(1), 21(1) and 23. So by virtue of such qualifications as prescribed in a state act, and on being registered in a state medical register, a person will be entitled to practice allopathic medicine under section 15(2)(b) of the 1956 Act. Based on this reasoning, this court partially overruled A.K. Sabhapati, which earlier ruled that person could practice allopathic medicine only if he possessed a recognized medical qualification. In Medical Council of India versus State of Rajasthan, 2 judges, it was observed that it would thus be clear that basic qualification of MBBS as primary qualification is a precondition for a candidate for being registered in the state medical register maintained by the state board. Identical view expressed in the decision of A.K. Sabhapati on the same point having been overruled in Medical Council versus State of Rajasthan also stands impliedly overruled. Coming back to the case in hand, the division bench in the impugned judgment relied upon A.K. Sabhapati to deny appellants right to prescribe medicine or to issue sickness or death certificates and held that appellants do not possess the recognized medical qualification. In light of the ruling in Dr. Mukhtiar Chand, this view of the division bench cannot be sustained. Therefore, there is no bar to register the name of the appellants in the state medical register. Now, the only issue for consideration is whether the right to issue prescription or certificates could be treated as a part of right to treat. In Dr. Mukhtiar Chand, it was pointed out that because prescribing a drug is concomitant of the right to practice a system of medicine, therefore, in a broader sense, the right to prescribe drugs of a system of medicine would be synonymous with the right to practice that system of medicine. In that sense, the right to prescribe an allopathic drug cannot be wholly divorced from the claim to practice allopathic medicine. The appellants are validly holding the right to treat certain diseases. So their right to issue prescriptions or certificates cannot be detached from their right to treat. Such right to issue certificates or prescription is embedded in the right to treat. One cannot and shall not be separated from the other. Once the right to treat is recognized, then the right to prescribe medicine or issue necessary certificate flows from it, or else the right to treat cannot be completely protected. Hence, even assuming for a moment that the 1915 notification is not there, still the appellant's right to prescribe medicine cannot be denied. In that view of the matter, the order of the division bench is set aside and that of the learned judges is restored. Therefore, the respondent shall make necessary amendments to include names of all diploma holders in the state of medical register for limited purpose indicated therein within a period of 6 months from when the appeal is allowed. So, my lord, it was on this basis that, my lord, we had claimed, my lord.
In this judgment, it appears that there was a specific relief sought for, that the right to issue certificates.
Correct.
That was curtailed by a notification.
That was curtailed by a notification on the ground that you cannot do it. That was granted in the first round, second contempt round. Well,
Is there a state medical register, Mr. Bora?
Yes, my lord.
Are there names included there?
My lord,
earlier they were.
yes, my lord, that is the, because in the new act itself, my lord, and in our affidavit also we have stated so, that they are registered under the
2015 Act,
yes, my lord.
not on the Assam medical. Just is part of, my lord, my is the Assam medical act.
Yes, my lord. In our affidavit also we have stated, my lord, at paragraph 10, page 525. Further, it may be stated that by government notification so and so, those who had completed diploma in medicine and rural health care course in the Medical Institute Jorhat were notified as community health officer, subject to submission of the certificate of registration as BSc professional issued by the Director of Medical Education. So they have been registered under the Director of Medical Education, my lord. They are obtaining
Question
the-
is, do you maintain a state medical register? Are their names included there?
Yes, my lord, obviously.
This paragraph doesn't say.
No, it doesn't say by, but probably, my lord, if they are
Can
registered,
you go back on probability?
right now I can ask them, my lord.
All right.
Well, my instructions are that they've registered us as community health professional under the 2015 Act, not under the act is Assam Medical Council Act 1999.
Is the statute available here? The
Assam Act, yes, ma'am.
Assam Medical Register Act,
Yes, ma'am. Assam Medical Council Act,
Council Act.
yes. Well, earlier it was given, ma'am. I just find out one more.
Is it in your paper book?
No, ma'am. It was separately given. Before we filed the compilation of judgment, we had given a separate bunch, ma'am. This my instructing counsel can. The first page is the Assam Gazette, Malad. It's something like
Yes,
this, Malad.
It's here. Medical Council Act 1999.
I'm obliged to your lordships. Please see. Malad, the preamble of the act says to provide for reconstitution of Medical Council of Assam and maintenance of a medical practitioners register for Assam for matters connected herewith. Then, Malad, please see some definitions. B, medicine means, this is section 3B, modern scientific medicine in all its branches and includes surgery and obstetrics, but does not include veterinary medicine and surgery or homeopathic, the Ayurvedic or the Unani or any other system of medicine. An expression medical shall be construed accordingly. Registered practitioner means any person registered under provisions of this act. Then please see, my lord, I over the page, the expression legally qualified medical practitioner. Now, this is most important, my lord. And all other expressions importing a person recognized by law as medical practitioners or a member of medical profession as used in any Assam Act. Or what was struck down was Assam Act. 2015 is an Assam Act. Or any act of the central legislature in force in Assam shall be deemed to mean a medical practitioner registered under this act.
Yes.
Then, my lord, please see, the council is constituted under section 3. Please have paragraph number, I'm sorry, section 15. The council
Section 15.
1(5), my lords.
Yes.
The council shall cause to be maintained. Am I with my lords?
Yes.
In the prescribed manner, a register of registered medical practitioners which shall contain names of A, all persons who are now enrolled in the state medical register. And please see the distinction, my lord. This is, in my humble submission, my lord, very important. There are two kinds of persons who could be registered. All persons who are now enrolled on the state medical register, and B, those who possess any recognized medical qualification referred to in that schedule. That is, my lord, IMC. Under the IMC Act, those, my lord, doctors. 16. It shall be the duty of the registrar of the council to keep register of registered practitioners in accordance with provisions of this act and of any orders made by the council from time to time, to revise the register, publish in the official gazette, and in such other manner as may be prescribed. Now, please see 70. Subject to other provisions contained in this act, and on payment of such fees as may be prescribed in this behalf by regulations made under section 34, any of the medical qualifications referred to in the schedule shall be recognized medical qualification for enrollment in the register of registered practitioners, provided that the council may refuse to permit the registration of name of any person. So that is on, my lord, these are the disqualification, sentence, etc.
Where is the schedule?
Yes, the schedule, your lordship will be pleased to find at the last page.
From time to time.
Yes, my lord. Sections 15, 17, 18, medical qualification is laid down or to be laid down from time to time in the first schedule of the Indian Medical Council Act of 1956.
So it is your case that your name was registered here.
Lordship, please. We were granted, well, I placed that registration certificates
That registration follows from this particular act.
from this act on my acquisition of, my lord, diplomas under the act which was struck down. I underwent that course. I was employed by, my lord, on basis of the registration, and no private practice, only with the government.
So what meaning is to be ascribed to this paragraph 1 in page 566?
566.
After discussions?
Yes, ma'am. Well, what they say is that we will register you only in line with 2015 Act. That is my understanding, unless the state says something else, my lord, because they have not so far disclosed about this decision at all. But there are three things on this. One, these are deliberations in the committee. The state doesn't appear to have taken any final decision. There is no notification. But
No,
assuming that this is the decision.
They have taken a decision that in view of Subhashis Bakshi,
Yes.
your, I think,
The demand of the so-and-so may not be entertained.
may not be entertained.
Correct. So that's the opinion of the committee. Because it was the state which issued a notification to constitute a committee. The state did not denude itself of the power to take this decision, but they wanted some expert advice. If your lordship see that notification, Malad, for a moment, which is part of the main writ. Kindly oblige me and have. And my lord, since I'm requesting your lordships to kindly have the memo of the writ. I'll refer to two more documents which I've earlier referred to. So please see 515. The committee shall submit a report along with suggestion recommendations. So the ultimate, my lord, at 515, annexure 26, the decision had to be of the state, which the state doesn't appear to have taken for. Otherwise, they would have forwarded us under the RTI Act. Well, I hope I'm clear, my lord. The committee shall submit a report along with suggestions, recommendations within 2 weeks to the Health and Family for taking further necessary action. So decision had to be by the state. The committee was constituted, my lord, if your lordship see the preamble, following members to examine the instant Supreme Court case. In pursuance of the Honorable Supreme Court order in the matter of Baharul Islam, a committee is hereby constituted with the following members to examine the instant Supreme Court case and submit its. So, my lord, for the time being, my lord, as it appears from the notification, since committee is a special creature under a constitution, under a notification, my lord, its powers would be as defined in the notification. But, my lord, for the sake of argument, my lord, if I were to assume against myself that what is referred to in paragraph 566 is the decision, then also in my humble and respectful submission, if I were to assume that this is verbatim accepted by the state, what is
Recommendation.
no, this is chairman of the committee. This is not the. Well, I've been just given one page just now, my colleague from the other side.
In fact, my lord, I have received just now.
No
Is that
problem.
recommend-
I'm not making a grievance, my lord. Not at all, Mr. Wab. So, my lord, I'm in fact obliged to my learned friend, my lord. It only proves my point. The matter relates to implementation of a judgment of the Honorable Supreme Court of India in SLP number so and so in the matter of Baharul Islam versus the Indian Medical Association, holding that community health professionals who would practice as allopathic practitioners in the manner as they were permitted in practice under the Assam Act in the rural areas of the state of Assam, as stated in para 25(4) of the judgment, and please to take necessary steps to safeguard the future of 856 students passed out from the Medical Institute, Joran. In this regard, a committee has been constituted by the Government of Assam, headed by the Secretary to the Government Assam Health and Family Welfare Department, to examine the instant Supreme Court case with a notification number so and so dated 3/4/23. Subsequently, number of meetings 22/6, 12/7, 27/7, and 7/9 have already taken place discussing the aforementioned matter regarding submission of report along with suggestions, recommendations to the government for taking further necessary action. Issue this recommendation. The committee recommends of upholding the judgment passed by the Honorable High Court pertaining to Community Health Officer in line with directives of the Honorable Supreme Court order. After careful consideration of the matter, the committee proposes to abide by existing rules of the Assam Community Health Professionals Registration and Competency Act, as it is not in conflict with the Indian Medical Council Act 1956 and has removed the basis of the judgment passed by the High Court. They are borrowing words, my lord, from the same paragraph that I'm, my lord, referring to. The committee is also of the opinion that although it can be read as this is because the Central Act IMC Act 1956 does not deal with community health professionals who would practice as allopathic practitioners in the manner as they were permitted to practice under the Assam Act in the rural areas of the state of Assam in para 25(4) of the Supreme Court judgment. Lord, may I, with your lordship's permission, pause here? or may I complete reading and make mine. However, the Assam Rural Health Regulatory Authority Act 2004 has already been declared to be null and void in view of IMC Act and rules and regulations made thereunder, considering Assam legislature not having legislative competence to enact the said law. So, my lord, the 25(4) is a direction issued because that act is struck down. In my humble submission, it is, my lord, being put to on the reverse. If your lordship is of the opinion that this is because the Central Act does not deal with community health professionals who would practice as allopathic practitioners in the same manner as they were permitted to practice under the Assam Act. But 2015 Act does not permit them to practice allopathic medicine. It was only the struck down Act of 2004 which permitted. Rules as mentioned in section 2G of the Assam are to be framed in appropriate manner whenever.
This perhaps is just reflecting what was there in the judgment at para 25.
Correct.
That's all.
And they said that this is, so after this also the state, my lord, with respect, it doesn't appear to have done anything. Then regarding redesignation, since the community health professionals have been designated as community health officers was say, vide the Assam Health Community Health Professionals, therefore, the matter of redesignation is not to be considered. Regarding creation of permanent posts, the committee was of the opinion that promotional benefit may be given to concerned community health officers having requisite qualification. Please mark the word, my lord, here. Rural health practitioner. That is upgradation to the post of senior community health officer once they complete 15 years of service in health sector. Consequently, the community health officers may continue to work contractually with fixed pay and increment as per existing procedure. Roles and responsibilities of the community health officer are to be kept strictly in line with the Assam Community Health Professional Registration and Competency Act, which is of 2015. Areas of jurisdiction of the community health professionals shall be at sub-center level or any other places as may be determined by the government from time to time. So these are recommendations as we see it from the chart itself. Well, since I was on the petition, I requested your lordships to have a look at the notification which was at 566.
What is the
515.
what is the nature of function of senior community health officer?
No, they are contemplating. The act doesn't talk about anything. 2015 Act, my lord, lordships have the act before your lordships. Please have, my lord, the 2015 Act, which your lordships will be pleased to find at 331.
Yes.
Preamble says to provide for registration norms and competency of community health professionals after passing BSc Community Health course and to give same to students who have completed or have been undergoing diplomas in medicine and rural health care, course in Medical Institute Jorat with that of BSc course to enable them to serve as paramedical personnel in the state of Assam. Well, your lordship will recall that by section 3, subsection 2, they have a deeming fiction over the page 333.
Yes.
Students who have already completed or have been undergoing the diploma in medicine and rural health course in Medical Institute Jorat on the date of commencement of this act shall be deemed to have completed or have been undergoing, as the case may be, paramedical course of BSc CH for the purpose of this act and shall acquire the same status to that of BSc Community Health graduates, and they shall also be entitled to, they shall also be registered by the director issued with the certificate of registration as community health professional. So what my learned friend was saying, we are issued is under this. Then, my lord, the duties page 334. Assisting medical officers as per competencies of community health professionals as laid down in section 5 of this act, as and when called for in coordination with NHPs, management of ASHAs, training and other responsibilities under NHM apart from overall administration and management of the community health center, etc., and quality and protocols of service delivery being delivered in so and so. Assisting medical officers as per competencies of community health professionals as laid down in section 5 of this act when called for organizing outpatient OT referral emergency. Now, may I pause here? It's like this, Malad, common experiment. When I go to a doctor, Malad, and if he wants to give me an injection, the compounder will rub Malad, the spirit. Doctor administers the injection. And Malad, I'm not saying this, I'm saying it with some sense of responsibility. I was shocked to receive, Malad, a representation addressed to me by all these persons. I made copies, it's addressed to me, but it annexes government documents. So they are given the duty of a valet for a car parking, making data entry. Malad, there is something like, Malad, dignity of labor, Malad. After having undergone 4 years, but just see under this NHM, latest of October 2025. Lord, page 4, please give it to them. Page 4 is the order. 1 to 3, your lordship may assume along. But there was not enough time, otherwise I can file it on an affidavit. In the interest of public service and in view of the upcoming health mela at so-and-so high school, the official employees are hereby assigned duties as enclosed. But please go with me and have, my lord, page number 9. Khaglesh Dole, CHO, Community Health Officer. Lordships have, my lord? Parking vehicle.
Who's that serial number 4?
4 is Amar Jyoti Sonowal, CHO, specialist. So is attached to a doctor. Then, my lord, over the page, if your lordships go with me to page number 13. His duty is at the registration counter. Queen Barua, CHO, Hathinapur AAM. Then page 14, serial numbers 5, then 1, 2, 3, 4, 5.
So this is perhaps so that some mela which has come up.
No, my lord, please go with me to page 18.
Hmm.
Well, earlier at this mela, we were diagnosing, we were treating. Now we have to do we have been asked to come with our own, well, please just see. Room number 1, registration counter. Ashik Ahmed, CHO, disease identification. Then Muqtadir Alam, disease identification. Then now if your lordship see at page number 22, data entry, referral management team, team convener so and so, so and so. So and so, and 15 number of volunteers, provision of laptops, webcam, color printer, paper cartridges, plus 12 so and so, ensure proper counseling to patients, creation of so and so. Over the page 119, 122. So we have to do that data entry, my lords. At page 24. At page 30. That's again an order dated 10/10. Name of medical officer. My lord, please see the column 1, 2, 3, 4, 5, 6, 7. Data entry operators and the name against team F, serial number 6, Jyotish Nath, CHO, Dalmore Vitha AAM. Now, my lord, interestingly, after the judgment was struck down, my lord, they issued orders of contract of employment. And my lord, I will request your lordships, my lord, to kindly consider, my lord, please take the order contract at page 340. I'm sorry, 294. The earlier contract. 294. Lordship will at page 295 find the date 12th June 2009, left hand side bottom. (296), my lord. The party, rural health practitioner contractual, will be member of health team. Am I with my lord, sir?
Yes.
In the institution where she is placed, she will have to perform his duty as per direction and guidance of the in charge of the institution, BPHA, and also will have to perform emergency shift as per duty roster prepared by the in charge of the institution. Schedule of so-and-so. She will have to attend OPT duty regularly, will have to attend emergency cases which come to the institution outside normal duty hours. She will organize laboratory services, passive surveillance, blood sites are to be taken, treatment for minor illnesses, common communicable and non-communicable disease, all of these, my lord. Then note, they will be able to treat illness, carry out different procedures, and to use different drugs specified in the regulation of the Assam Rural Health Regulatory Authority Act 2005 and not beyond that. Moreover, they are not allowed to handle medical legal cases, post-mortem examination, but they will be able to provide first aid even to those medical legal cases attending OPD emergency where there is no doctor. Lord, please have this page open and compare it with the new contract, which your lordship will be pleased to find at page 340. My lordship will find the date. From the date, Mr. So-and-so has been engaged as CHO. Muhammad Ashraf Kamal Barkhuria has been engaged as lordship will find CHO at so-and-so from date 20th of February 2016 till 31/3/2017. So, my lord, it's after the judgment of, my lord, the Guwahati High Court striking down and after the redesignation by page 339. Please go with me to 342. Please see the health thing. Rural health practitioners contractual will have to work in a team with 1, 2 ANM and female attendant who are working in the sub-center. My lord, ANM is auxiliary nurse midwife and female attendant. Schedule so and so. Then, my lord, curative work, other IAC activities. Then, my lord, at page 344, this is most important. So, on paper, they say E. Disease that can be treated by rural health practitioner is placed at Annexure 1. Drugs that can be prescribed by RHP is placed at Annexure 2. Any other work assigned by the District Health Society, they will be able to treat illness, carry out different procedures, and to use different drugs specified in the regulation of Assam Rural Health Regulatory Authority 2005 and not beyond. Moreover, they are not allowed to handle medical legal cases, post-mortem examination, but they will be able to provide first aid even to those in so-and-so. Is almost verbatim the same except some change at page 342. Curative work. Now, my lord, the registration certificate at page number 346. Your lordship will be pleased to mark it is not under the Assam Medical Act 1999, Medical Council Act 1999. It says so specifically. This is to certify.
Just one minute.
I'm so sorry. T46, my lord. You know, they came out with a notice on 6/8/15, which is annexure 18/345. All
346.
ARA, Assam Rural Health Regulatory Authority registered candidates are hereby directed to
You're
apply.
referring to 346.
345, my lord. Just see pursuant to which they 345 is the notice. All ARA, Assam Rural Health Regulatory Authority registered candidates. So we are registered, but by virtue of that act under the Medical Council Act 99 are hereby directed to apply for registration as community health professionals at the office of the Director of Medical Education Assam on or before 20th August. The application form for registration as community health professional is available at the official website of the Director of Medical Education Assam, www so and so. Original ARA registration will have to be submitted along with the application form. Please see the next page. Registration certificate. So and so has been registered as community health professional under the Directorate of Medical Education Assam. Her registration number is so and so, is competent to perform duties as per competencies of the community health professionals as indicated in the Assam Community Health Professional Registration and Competency Act 2015.
Yes.
This is by virtue of that deeming provision, my lord. Then, my lord, I had indicated, lordships have already seen it, my lord, only to refresh your lordship's memory in light of the present, that as far as back immediately after the judgment on 6 November 2015, the judgment of the High Court was earlier, 6 November, immediately after the judgment. My lord, the Deputy Secretary to the Government of Assam writes to the Deputy Secretary, Health and Family Welfare, I'm sorry, to the Director of Health Services, request you to furnish a clear proposal with proper justification for creation of post of rural health practitioners along with all relevant information. And that continues, my lord, that communication in 2016, as your lordship will find at page 350.
350.
Yes. The first one that I placed was 348. That letter is 6 November.
Yes.
Then 2016 is 10/3/2016. With reference to the above cited government letter, in continuation of this directorate proposal number so and so dated, I have the honor to submit herewith proposal for creation of the post of RHP as received from the DME Assam. We did the letter so and so 18/1/2016 for information. So despite the judgment, what the government was of the opinion, if your lordship see at page 351, rural health practitioners, number of post 421, pay band 8,000, 35,000, grade pay, DA, HRA, MA, total remarks. So this was the proposal, which was the basis of my arguing the principle of legitimate expectation before your lordships. So on one hand, despite the judgment, they are doing this. Other hand, there is a committee. Committee makes recommendation and there is no final decision. That is where, presently the matter would, rest on factual basis.
This term rural health practitioners
Lordship, please.
was under the 2004 Act.
Under the
earlier.
DUFA. Yes, my lord. And it finds, my lord, it's mentioned in a different way in section.
Is there any other act governing these posts
No, madam.
from other
None to my knowledge, my lord, in Assam.
so even after setting aside, when was the judgment? The Apex Court judgment?
Yes, my lord, this court judgment is dated, my lord.
No, Apex Court.
Apex Court is 24 January 2023. But this court, my lord, there was no stay, my lord. So the striking down was on 30/10/2014. Annexure 14, page 322.
So perhaps this, I don't know, but this must have been proposal initiated prior to the striking down of the act.
No, with great respect, my lord. I tell your lordship why. Yes, my lord. My lord, if your lordship please sees, my lord, that document that I placed for your lordship's consideration at page, only a moment, my lord.
350 or 348.
Yes,
So there is a proposal, but. the
but please
question
see,
is-
my lord, please see reference, your letter dated 12/2/2050. It's after the act. Proposal is, my lord, after the act, with great respect.
the Proposal.
Yeah, my lord,
But when the statute doesn't prescribe,
my lord, I would only say this one, with, my lord, utmost humility at my command, that, my lord, all that I place this fact, not, my lord, that I have some overarching right, but my right, my lord, to practice follows from, say, para 25(4) of the Honorable Supreme Court decision. And, my lord, all throughout, even before that decision, the government of Assam was also in tune with, my lord. But it is like this: if something happens, my lord, during, my lord, there is an act. Act prescribes that so many things happen. My lord, I had given that example to your lordship, that there is an act which makes something an offense. While the act was in force, some person is tried, and, my lord, he is. And I placed that Bombay judgment also, the first judgment, 7 honorable judges, my lord, of the Honorable Supreme Court. Does it completely efface everything, my lord? Or does it, my lord, have the, my lord, does it save all those privileges, liabilities, etc., which occurred lawfully during the continuance of the act? My lord, if I were to ask a question to myself, that while striking down the act, even if it was presumed that we were parties and this relief was asked for, could the court, my lord, with great respect, have granted that relief?
assuming your rights are protected.
Lordship, please. Lordship.
This is not a case of, well, let us say, in a given case, you pursued a particular degree in an institution which was recognized by the UGC or AICTE at the relevant point in time. So you obtained your degree.
Lordship.
Thereafter, the institute was de-recognized.
Lordship, please.
Now, the question would be whether your degree was valid.
Lordship, please.
Of course, it would be valid because you had got your degree from an institute which at that point in time was not de-recognized or
Not struck down or
struck down or anything like that. Here is a case where, yes, your degrees, your
diplomas.
your training, everything is protected.
Lordship. And given by a recognized institution under the act.
Right. The question would be in the event of a vacuum in the subsequent act,
Lordship, please.
what directions can be issued by the court
Lordship, please.
to continue to direct the state to continue to allow you to practice or give you your status in practice, as it were, under the 2004 Act, which is struck down.
Lordship, please. Lord, my humble and respectful submission and answer to what has fallen from your lordship, A, my lord, that cannot be more than 25(4). I also cannot travel with respect, my lord. I will put it like this, that the judgment is binding upon me and them, because we were partners. Therefore, in tune with this, they will have to make that necessary apparatus.
That's right.
I can't be asking that reinstate me as RHP, my lord. Only thing, therefore, my lord, if your lordship just sees that line again, and that is of crucial importance in my humble submission, at page 513. Consequently, the subsequent legislation, namely the Assam Act of 2015, that the Assam Community Professional Registration and Competency Act. My lord, please keep in mind 3(2), deeming fiction. Their lordships have that in mind, that whatever you have taken the degree, so that on the contrary reinstates. My lord, suppose if I didn't have the degree of DMRC, there was no question of treating me to be equivalent to CHO under this act. That's why I placed Malon section 3(2). Enacted pursuant to the judgment of the Guwahati High Court is a valid piece of legislation as it has removed the basis of the impugned judgment passed by the Guwahati High Court. The 2015 Act is also not in conflict with IMC Act 1956. This is because the Central Act, namely IMC Act, does not deal with community health professionals who would practice as allopathic practitioners in the manner as they were permitted to practice under the Assam Act in the rural areas of the state of Assam. Lord, admittedly, the 2015 Act doesn't permit this. I had invited your Lordship's attention to the definition, Lord, in the paragraph, first paragraph itself, that what their Lordships refer to at page 377.
Yeah, so therefore, this particular observation, subject to correction, will it appear to be legislating something which is not there in the Act of 2015? If allowed to implement.
My Lord,
So this para 4 has two parts.
yes, my Lord.
First is your status is protected.
Lordship, please.
Your status is protected. The Act legislation 2015 is also protected.
Lordship, please.
Legislation 2015 recognizes your
Lordship, please.
qualifications, degrees, etc.
Lordship, please.
The only gray area is the third area, where you are permitted to practice as allopathic practitioners.
Lordship.
When the statute of 2015
Yes, Lord.
doesn't have any basis to show that, yes,
They can be so
they
permitted.
can be so permitted. So the only options available now would be to make necessary changes in 2015 in the line of the Apex Court judgment.
That could be one, my Lord. And my Lord, secondly, or my Lord, your Lordship may consider, my Lord, appreciating the submission, that this could be read as if, my Lord, as I'd indicated and I'd showed, that, my Lord, that striking down is in future. It's made, my Lord, it saves everything what has been done. It's a prospective effect.
All right, if we take that, your functioning will still have to be governed by a set of statute or rules or something like that.
No, but may I say this? My Lord, there are ways in which your Lordships.
Let me
I'm sorry.
make myself a little more clear.
Lordship.
So for instance, let us say you are employed as a rural health practitioner
Lordship.
in the earlier Act, 2004. It is possible that over a period of time, government may think of giving you promotion level, which will be there in senior or maybe some other nomenclature, etc.
Lordship.
Now, this will have to be specified under the statute or a set of rules, or in the absence of them, some notification by the office memorandum by the government. Here is a case where your status has been altered, nomenclature has been altered.
Nomenclature.
Now, for you to be given back the status which you had enjoyed in 2004, besides the fact that there'll have to be appropriate orders coming from the government, what would be the effect on your service progress? Because there's nothing in the rules.
Well, may I
nothing
say
in the
this?
Act.
Well, may I say this? My Lord, even under the Act which is struck down, I'll refer to as the 2004 Act, except stating that there is RHP, there were no rules which had post promotions, etc. Only what that Act permitted to do was, in terms of the provisions of the Act, a limited right to practice after acquiring the diploma.
See,
In allopathic medicine. I'm sorry, if your Lordship permit me.
no.
Instead of
Let me counter that. See, had this para 4 not been there, there could have been many options as to how to interpret this situation.
Gotcha.
Number one, there could be a direction that you fill up the gap. Number two, that whatever you submit, that your position is as it was earlier, prior to striking down, is protected. Therefore, that position will continue till subsequent legislation, etc. is coming. Here is a question where the apex court has clearly laid down. Para 4,
Lordship,
Roman 4.
Lordship.
You urge your, you stake your claim from this particular paragraph.
Lordship.
So this, before the High Court, it doesn't call for any further interpretation or expansion. We'll have to read whatever is there in para 4.
Correct. I will not, my lord, even make any attempt to, my lord,
No,
even
we are
to
expressing-
ask your lordships to, my lord, read anything further than this.
We are only expressing our.
Yes, my lord, tentative, my lord,
limitations.
that's, my lord, with a view to,
So, the only thing that flows from this para 4.
my lord, who would practice? My lord, please see the, my lord, as I was saying, my lord, if your lordships grant me a moment, my lord, I'm just, my lord, giving an example. But there are ways in which this paragraph could have been, my lord, phrased. One is that we protect the rights easiest way. 2, that they shall continue to hold. 3, that the strike, we declare that the striking down of the act in 2014 is from the date of this judgment, and whatever degrees are acquired are saved. Now, please see the 4th manner in which the lordships have deemed it appropriate to say. It does not deal who would practice. My lord, it is present, continuous, and future tense. Well, we take the language as it is. This is because the Central Act, namely IMC, does not deal with community health professionals who would practice, means present, continuous, and future, as allopathic practitioners in the manner as they were permitted to practice under the Assam Act. Well, refers to past. And who would practice as allopathic practitioners? In what manner? Well, let me split this. That community health professionals would practice as allopathic practitioners. That's 1. 2, in what manner? The answer is in the manner as they were permitted to practice in the Assam Act, which is the 2004 Act, and where in the rural areas of the state of Assam. My lord, your lordships know, my lord, that the law is that judgments are not to be read as edifice of statutes. They have to be read as it is in light of the facts that were before the court. That's the ratio decidently. This is one of the direction which comes, my lord.
Yes.
And that is why they reiterate. The said legislation of 2015 is not in conflict with IMC Act because they have removed the basis. That's what is the first paragraph, first line of that paragraph. Hence, it is not hit by 66, entry 66 of list 1, and is within the so and so. Okay. This would be, my lord. Very grateful, my lord. We have troubled your lordships, my lord, too many times.
We are here to be troubled.
No,
It's
no.
not an issue at all.
My lord, your lordships are always, with respect, my lord, very kind, my lord, to all litigants, my lord, and the
Mr.
lawyers.
Bora, is there anything else you want?
No,
to
my
know?
lord, my final submission is the recommendation, my lord, as I submitted on last.
No, that recommendation is again not final.
My lord, it is the final recommendation because after.
What has happened after this recommendation?
My lord, the recommendation is lying with the government, my lord. As of today, that is my instruction, my lord. But otherwise, my lord, whatever the recommendation says, that my lord, because my lord, 2015 Act, whatever functions and responsibilities and competencies of the CHO has been given in the 2015 Act, my lord. So recommendation also says that that should be performed by the.
With
petitioner,
respect, that
my lord.
recommendation doesn't take the spirit of para 25-4. That's the only, my lord, point at which both of us are in, my lord, respective submissions before your lordships. Very grateful, my lord.
Right. We heard. Mr. Hiramal. Present senior counsel assisted by Mr.
Dilemma, then Mr. Majumdar.
And Mr. EMS Mujumdar, learned counsels for the petitioner. Heard Mr. TP Pora, done a standing counsel for the health. The respective counsel have concluded their arguments. Hearing concluded, judgment reserved.
Lordship. In my
Yeah,
my
we are
note
giving-
of argument, I've already submitted on
Yes,
day one.
Yes.
That's.
We
before
are,
you.
we are giving you back the affidavit. The court copy is already there.
Lordship.
It has come.
Lordship. Very grateful. Much obliged, Mullah.
Obligement.
I was informed your lordships have now another responsibility also in very sensitive one. That's what I read in the papers. But I wish my lords all the best.
Thank you.
May I have permission to leave? Mullah?
Yes, yes, certainly. You manipulate. Yes, but people like Matok.
Daily list for admission, item 2 and 3. May I please it your lordship?
You have impleted.
Not
Contempt
impleted,
contempt petition,
not impleted,
huh?
not impleted,
You have been permitted.
is lordship. But lordship, the honorable coordinate bench of this honorable court order dated 13/6/2025 lordship, wherein lordship submit the learned counsel for the respondent lordship to granted 2 weeks time to obtain instruction lordship to complete the previous order lordship, that is 31st of August 23 lordship. And the subsequent date lordship, when the matter was called upon before the honorable coordinate bench lordship, that is 19/7/2025 lordship, learned counsel respondent had made submit that lordship that he has filed an appeal lordship against the order dated against the IA number 1350/25 lordship. But lordship said writ appeal has been second time dismissed by this honorable division bench lordship. This is the writ appeal, your lordship.
We have the cover.
Yes, sir. That in this
What has happened to the writ petition?
your lead petition lordship order dated 31st of August 2023 lordship. There is a distinctively direction issued by this coordinate bench lordship, particularly in para number 7. May I please to read your lordship? 31st of August 2023. As such, the Director of Employment and Craftsman Training Assam respondent number 3 is directed to do needful for the purpose of giving the benefit of compassionate family pension scheme of the state to the petitioner on the death of her husband, Prafulla Barman, in consultation with the Commissioner and Secretary to the Government of Assam in the Skill, Employment and Entrepreneurship Department, and further it so request with the Finance Department of the state as well as the Chief Secretary of the state. And the fix again, that is on 4/10/2023. When the matter was again raised before the coordinate bench lordship, that time lordship, the government has filed an appeal against the said order lordship, that is 31st of August 2023 lordship, that is a division bench order. One writ appeal, that is 48/24 lordship. The said writ appeal has also been dismissed by this on division bench order dated 23 of February 2020. So may I please to submit lordship?
What is that
This writ
number of
appeal,
the appeal?
writ appeal has been dismissed.
What is the number of the writ appeal?
48/24 lordship.
48.
Yes, lordship. That is the previous writ appeal lordship.
Previous. Subsequently, it has been dismissed.
Yes, lordship. The subsequent.
235.
Yes, lordship. By compliance, the said writ appeal direction lordship, government has filed an IA lordship. That
In-
is for alteration and modification of such order lordship. The said order is lordship, IA number 1350, দ্বারা IA order, I record to deduction দ্বারা। 13/6/2025 lordship. 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 13/6/2025 l 135024. This IA has been filed by the government, taking stand that they have filed a lead appeal, wherein lead appeal had directed to approach before the learned honorable single judge lordship. Therefore, lordship, the present IA has been filed with a prayer for modification and alteration of such order. But during the course of hearing, lordship, the honorable coordinate bench of this can be Paris order dated 28th of February 2024. In such IA lordship, one another order that is 28th of February 24.
This was also appealed against.
Your lordship.
Was this order, did?
Oh,
was
yes,
this order
lord.
appealed?
Against this order, lordship, the government has another file writ appeal, lordship.
235.
Yes, lordship. 235.
That
May I
was
please?
dismissed.
Yes. In this writ appeal, lordship, may I please to read, lordship? That
No,
is
the writ
clearly
appeal is
mentioned there.
Dismissed.
Yes, it has been dismissed, but the fact has division bench has clearly mentioned that the frequent situation has arisen in this appeal. The case concerned the widow of a government employee, namely Profulla Burman, who worked as a Sokidar at the Industrial Training Institute, Borpeta, under the government of Assam. He was appointed on 22/1/19 after a prolonged litigation. In the fact, the name was recommended by the district selection committee, but in the final selection name list, his name was not there. The recruitment exercise was of the year 2005-6. In the connection, a writ petition was filed by the concerned employee and others, wherein a direction was issued to the ensuring department to the government to provide employment to the employees and others. All the travels lead, very interestingly mentioned here, lordship. All the travels lead to the demise of the employee within a few months of his joining service. He could not complete it, only 5 months, 12 days in service he could complete. This was taken as a ground by the state to deny compassionate family pension to the widow of the employee on the ostensible ground of the employee having died in harness. Division bench has clearly mentioned that whatever ground they have taken by the government that not completed requirement service period 1 year, that is mentioned as ostensible ground, lordship. Without having completed 1 year of continuous service, entitled his wife to avail compassionate family pension scheme. The widow of the employee, the respondent herein, challenged such decision of the government by writ petition number 71422, in which an interim order was passed on 31st of August 23, directing the respondent number 3, Director of Employment, Craftsman Training, Assam, to give the benefit of the compassionate family pension scheme of the state to widow of the employee after consultation with the Commissioner and Secretary to the Government of Assam in the Skill and Employment and Entrepreneurship Department, and perhaps also with the Finance Department and the Chief Secretary of the state. The aforementioned interim order was challenged by the government in writ appeal number 48/24. However, the challenge to such order was dismissed by coordinate bench of this court by order dated 23/2/2024, that is lead appeal arising out 48/24 laws, holding that the appeal state had opportunity to place
All
their
right,
case
it is,
before the last.
ultimately they have been asked to agitate all this before the single judge. Yes, what is your case in the writ petition?
Lead petition case, lordship, the petitioner has seeking pensionary benefit, lordship. Accordingly, lordship, the previous date honorable court has 31st of August 2023, lordship, that wherein interim order has been passed, only ground that, lordship, the case is the very frequent, has there is a for monitoring the honorable single bench, lordship, to entitle her pensionary benefit. Therefore, a specific direction has been passed in para number 7, lordship. In such order, lordship, the learned honorable single judge has stated that, lordship, in para number 5. Through the Director of Employment and Craftsman Training, Assam, response number 3, in its said affidavit stated about the compassionate family pension scheme of the government in lieu of compassionate appointment, and the same time also stated that in terms of the same.
Why the petition, pensionary benefits are not released?
My lord, we have filed our affidavit, my lord. to our affidavit in opposition, madam, the petitioner has not filed his reply. But that's a submission, madam. Now, my lord, the point is that, my lord, if your lordship kindly see the prayer of the,
Affidavit filed by respondent 3.
my lord,
Yes. What is your statement here?
my lord, we have, my lord, lordship may kindly come to paragraph number 5, my lord, page 39. The main issue is that, my lord, he worked in the department for a period of 5 months, 12 days, my lord. That is the case. And as per the pension rule, my lord, under rule 140, minimum 1 year is required.
There are judgments of this court that the services rendered earlier will be used
My
for
lord.
making up.
Yes, my lord. And my lord, lordship may kindly
Is
come.
that the only ground?
That is the ground, my lord.
That is the only
That
ground.
is the ground.
He is put in 6 years,
No, my lord, 5 months.
5 months, 12 days.
5 months.
5 months.
And how many years has the petitioner worked?
He worked for 5 months, 12 days, my lord. Less
That
than
is
1 year.
after regularization.
No, ma'am, not regularized. Before regularization.
Huh?
He worked only for a less than 1 year, madam.
Your lordship,
When was he appointed?
lordship,
Initial appointment?
initial appointment lordship in the year of 2005 lordship. So in
my lord.
the your lordship, the IA lordship, that is 135024 lordship. When the honorable court has disposed of, will categorically mention, may I please to draw attention before this court 5/6/2025 plus. Entire scrutiny or hearing has been conducted lordship. Last 2 years has been pending in respect of final decision of this in respect of decision by
Eh,
taking the final decision lordship. That is 5/6/2025 lordship. The inquiry has been carried out lordship by this honorable court. So may I please draw attention para number 2 lords. That is order dated 5/6/2025. By order dated 28/2/2025, will call for the records bearing number so and so in original from the Commissioner and Secretary Skill Employment Entrepreneurship Department, opposite party number 4. By the same order dated 28 February 25, appellant was directed to place the record of the file bearing number so and so in original. On 9/6/25, Director of Social Welfare, Assam issued an advertisement inviting the application from the intending eligible physical disabled candidate to fill up the 6/6 number of backlog vacancies in grade 3 and grade 4 posts in different department of the government of Assam. And para number 5, very interesting lordship.
Yes.
106 number of petitioner, including the husband of the petitioner, Popular Burman, serial number 48, read petition 142411, and other versus State of Assam and other 7 number of petitioner, read petition 399411, who were all recommended by the district level selection committee for such grade 3 and grade 4 posts. Under the person of disability PWD quota as their name were not found in the final state level selection committee recommendation by the state committee, being agreed preferred the read petition noted above. Event of that in para number 7, honorable court has mentioned that the after made proper observation lordship, that is lordship, by communication dated so and so, under number so and so, the labor and employment department of the state informed the director employment craftsman training Assam about government approval with regard to the appointment of the husband of the petitioner, Popular Burman and other under grade 4, 3 and grade in grade 4 posts under the category of reserved for differently able person, directing the state directorate to take necessary action as per Finance Department Office Memorandum number so and so dated so and so, by following all norms and procedure indicating further that the same has approved by the Chief Minister of State. So lordship, this observation has been carried out only by compliance of Honorable Division Bench earlier order 48, earlier WPC number 48, writ appeal number 48/24 lordship. So lordship, by compliance the said order lordship, honorable single judge has carried out entire inquiry lordship. Accordingly lordship, the honorable single judge has finally stated that in para number 32 and 34, para number 32 Honorable Single Judge has mentioned, for the reason above, this court of the opinion that interlocutory application being devoid of merit does not call for the such alteration modification of the order dated 31st of August 2023. Past is connected with petition number 71424, preferred by the opposite party number 1 as the read petition. And 34, return the record bearing file number so-and-so of the Skill Employment and Entrepreneurship Department, Government of Assam, DET, so-and-so of the Director of Employment Craftsman Training Assam, Mr. S.P. Das, Ranil Standing Council for the School Employment Department, Government of Assam, obtain necessary acknowledgement from them. So entire this hearing has been conducted by the Honorable Single Judge by compliance of the earlier writ appeal 48, your lordship, 24. So lordship, why again the hearing should be required, lordship? So he is bound to comply with the such order that is previously order passed by the 31st of August 24 for giving pensionary benefit, lordship. Event of that, lordship, the final writ appeal, lordship, 2235-24, lordship, the division bench has very clearly mentioned that whatever ground government has taken, that is the ostensible ground, and the petitioner husband has getting such his service only for travels writ, lordship. Previous occasion, petitioner husband has filed a writ petition before this honorable court. This accordingly, this honorable court has directed to appoint the husband of the petitioner within a period of 4 months, but not appointing the husband of the petitioner at within specific time. That is fault of the government, not the fault of my husband also. And event of that, the government has not taken leave of the court. That why they should be appointed the husband of the petitioner in so late, lordship. So lordship, they are bound to compliance the order, lordship. That is only unnecessary. What says the honorable court?
Where is the first order?
That is the first order, 31st of August 2023, your lordship.
31st of August.
In para number 7, your lordship.
No. First writ appeal order.
First writ appeal order, lordship, 45.
Is it? Give us a copy.
Yes, I have. But I'm sorry, sir, this is my personal copy, lordship.
No problem.
Lordship, may use this one, madam.
Hearing the code now.
By compliance, the said order, lordship, IA has been dismissed, lordship. And honorable single judge has finally once again decided IA, lordship.
Where is the compassionate family pension scheme? Is it enclosed somewhere
Page 45, madam.
of the writ petition?
Of the madam, affidavit in opposition, madam.
Affidavit in
Page 45.
page 45. When did the husband expire? Husband of the petitioner.
At 3/7/2019. 3/7/2019. 3rd of July. 2019.
Against the order passed earlier
My lord.
by the coordinate bench.
My lord.
Was any appeal filed?
Yes, my lord. Appeal was filed.
Filed.
Which one earlier before appointment?
First litigation.
2005, my lord.
Ah,
No, my lord.
no appeal was.
In that case, my lord, we are not a party, my lord. This department was not a party, my lord.
So
So they-
direction is issued to whom?
It is
You are appearing for which department?
for skill employment and entrepreneurship department.
Skill, employment and
Entrepreneurship.
entrepreneurship.
Yes.
In the first writ petition was filed by your husband.
Yes, Lordship. My husband, Lordship.
Which writ petition number?
Yes, your Lordship. I have a order, Lordship. Same has also been record, Lord. Another, this one is at the time of hearing single.
Page number 13 of your writ petition.
Yes, Lordship.
Is that the order?
No, not that.
So now, Lordship, there are the two number of writ petition, Lordship, file. One is the connected, Lordship, another connected writ petition, Lordship. My husband name has been enlisted in serial number 48, Lordship. Available with me.
Not a part of the pleading.
No.
Is it not a part of your petition?
No.
Lordship, there are the two number of writ petition earlier has filed, Lordship, by my husband, Lordship. There is then categorically mentioned, Lordship. One is a 1424/11.
1424.
Yeah.
And another is 3494 of 2011
Here is that, your Lordship, 1424.
and 3494.
3494 or 3994?
3494, man,
3494.
of 2011.
Filed by, what is the name of your husband?
Prafulla Barman, your Lordship.
He was part of the writ petitioners. He was one
Yes,
of the writ
Lordship. He's
petitioners.
enlisted, his number is CM number 48, Lord.
48 in WPC 1424.
1424. 1424, thus I have collected certified copy, Lordship, but the certified copy, Lordship, not categorically mentioned of all the petitioner name, Lordship. But I have submitted case number 1424/11, Lordship.
3492.
Original report is there, Lordship, I think. His name we enlisted.
No. 1424.
Hmm. 48. Serial number 48.
Was he a person with physical disability?
Yes, your Lordship. Yes, your Lordship. That is, your Lordship, after proper scrutiny, Lordship, honorable single judge, Lordship, in para number 13, in the IA, Lordship, which was already been dismissed, Lordship. In this order, Lordship, it itself mentioned, Lordship. May I please to read, Lordship. By communication dated 15/12/2016 under number so by the Labor and Employment Department of the State, directed the Director of Employment Craftsman Training Assam to submit the detailed proposal for filing up the number of the grade 4 posts under the person with disability category with the reference to its earlier letter number of so. In para number 14, relevant para number 16. Director Employment Craftsman Training Assam communicated number so dated so forwarded the format 1 and 2 for filing up the grade 4 posts lying in 3 different districts of the state, proposing to be filled up by the person from the PWD category in compliance of the High Court order dated 23/4/2023, Lordship. So, Lordship, the previous, when my husband was filed writ appeal, in such writ appeal, there is a specific direction, Lordship, all department, Lordship, under Government of Assam, Lordship, to do needful, Lordship. Now, finally, Lordship, in such writ petition 142411, Lordship, wherein my husband was filed the writ petition before this court, Lordship, there is a direction keeping in view the mandate of the Person with Disabilities Act, all the concerned administrative departments shall cooperate with the Social Welfare Department. Meaning thereby, Lordship, all the administrative department has a duty bound to follow and carry the order of this honorable court. Now he has taken stand that, Lordship, at that time he was not made in party, Lordship. What tabular submission he made before this honorable court again and again, Lordship. Last 2.5 years, Lordship, order of the honorable court has not carried out, Lordship, and this order has remained unimpacted, Lordship. So, Lordship, personal appearance may be given to the Director of Enforcement Department, Lordship, why he should not be carried out order of this honorable court. Division bench of this court, Lordship, there is a categorically mentioned that whatever ground they have taken, that is the ostensible ground, Lordship. And he has thus, my husband has has been appointed only for the travels lead of the court, Lordship. He is fighting in the year since the year of 2005, Lordship, and recruitment drive has been carried out in the year of 2005, and accordingly he is filed writ appeal before this honorable court, Lordship, 1424 and such other connected writ petition, Lordship, wherein challenge the recruitment drive. Accordingly, the honorable court has directed the all administrative department, especially to the welfare department, Lordship. And Lordship, direction was issued to carry out the recruitment drive, Lordship, and appoint the husband of the petitioners and other petitioners, Lordship, within a period of 4 months, not carried out such order, Lordship. So that is one of the gross negligence and violation of negligence of the authorities, Lordship. Accordingly, Lordship, by compliance the previous order, Lordship, the government has constituted a committee, Lordship, hearing, Lordship, to hearing, Lordship, Honorable Coordinate Bench order dated 5/6/25, Lordship. The order itself reflected that the committee has been constituted, Lordship, even in presence of the Chief Minister of Assam, Lordship. So why should again required for hearing, Lordship? He is bound to compliance. Personal appearance may be given to the Director of Encroachment Department. He showed reluctant view against the order of this coordinate bench, Lord. Each and every paragraph, Lordship, Honorable Single Judge has categorically mentioned that, Your Lordship, if Your Lordship has perused the such order, Lordship. In para number 28, that is also most important, Lordship. As noted above, the court, by its common order dated 23/4/15, passed in writ petition number 142411 and 349411, directed to complete the exercise within a period of 4 months, and the state authorities, including the Skill Employment and Entrepreneurship Department, Government of Assam, as well as the Director of Employment Craftsman Training Assam, did not take any leave of this court, exercise leave of this court for extension of time to comply with the direction of the court dated so passed in the WPC number so. So they did not take leave of this court. Why they should be appointed the husband of the petitioner in later, Lordship? That is fault of them, Lordship. Now he has taken the ground, ostensible ground, Lordship. They are not completed qualifying period of service.
Yes, Mr. Das.
He is bound to comply, Your Lord.
Lordship, on the first writ appeal, which was disposed of this by this division bench.
There is an order passed by the court
Madam,
on
31st of 8.
31st,
Of 8, madam.
where there is a categorical direction
Yes, madam.
to comply.
Yes, madam.
Now, you filed a writ appeal was not.
Read appeal, madam, if I am allowed to read the last line, madam. Read appeal 48, madam, order dated 23/2/2024. The Honorable Division Bench has categorically mentioned, in such circumstances, we are of the view that the appellant state is having an opportunity to place their case before the Lanet single plus, just clarifying the stand of the state government. So, madam,
What is your case?
our case is that, madam, this OM, madam, as per this OM, the Your Lordship comes to page 46 directly,
46.
madam. The OM, madam, for compassionate
46 of
of our affidavit, madam.
your affidavit has only 46, yes.
Madam.
Hmm.
Last third para, madam. Last third para.
Hmm.
As per the provision, the said scheme, where the employee dies before superannuation after completing minimum 1 year of continuous service, the family pension equal to so and so. So, madam, this, as per this, madam, 1 year minimum service required. And this OM, if Your Lordship comes to the earlier page 45, the reference which has been given, reference number 1A, Assam Service Pension Rule 1969. Reference B, Assam Service Revision of Pay Rule 2017. Reference has been taken for compliance as per the Assam Pension, Assam Service Pension Rule, madam. And as per Assam Service Pension Rule 140, it has been mentioned that minimum 1 year is required, madam.
No objection, Lordship. He is still, he now presently he is concealed the fact, entire fact from this honorable court, Lordship. Your honor, Lordship, kindly be paid his Lordship. There is a less than 7 years.
Reply. Please take your seat down. You'll get
Your
your
Honor.
opportunity to reply. Yes.
Yes, madam. If Your Lordship kindly use that Rule 140, madam, of the pension rule, madam.
Hmm.
What is it?
Pension rules. Yes.
140, except as otherwise provided in Rule 142, a family pension not exceeding the rate mentioned in Rule 141 will be admissible in case of death of an officer while in service or after retirement on or after 1st January 1964. If at the time of the death, the retired officer was in receipt of the compensation, invalid, retiring or superannuation, in case the death while in service, the government servant should have completed a minimum period of 1 year of service, madam. We are stuck on this, madam. Otherwise, madam, we have all compensation for the petitioner, madam. But we are.
But court has already held
Yes, madam.
that had he been appointed at the relevant point in time, he would have completed 1 year.
That is the madam, earlier round of litigation, madam. But he, as far
No,
as
even in this order.
madam, it has been mentioned, madam. But madam, but he was appointed, madam, we are on the date of appointment as per this rule, madam. When was he appointed?
We are aware of that, but there is an order of the court which has interpreted that.
Madam.
Court said that had he been appointed on a date,
Madam.
when he ought to have been appointed, he would have completed 1 year. It is the court's finding that because of default on the part of the department, there was delay for which he was not responsible. That is the finding against which you appeal.
Yes, madam.
Appeal, perhaps you did not draw attention of the appellate court that this is the finding which has the effect of laying the controversy into a finality.
The division bench, madam, my Lanet also appeared in that case, madam. He also appeared in the division bench.
You had filed an appeal.
We have also filed, we haven't filed, madam. But
So what purpose did you file an appeal?
for recording this order, my earlier order, 31st.
But that has been turned down.
Turned down, madam, with a observation, madam.
What observation?
Lordship, I have already read, madam, the first writ appeal. First writ appeal was disposed of on 23/2.
And insofar as the earlier writ petition is concerned. earlier-
2011. Yeah.
Earlier writ petition has also come to a conclusion that they ought to have been given the benefit of employment at the time. And direction was given to make necessary verification and issue appointment orders. Mr. Soikia, the rule and the scheme lays down a minimum service of 1 year.
Absolutely right. That is that is why, your lordship, the previous order coordinate bench of another coordinate bench of this court, lordship, that is one observation has been made out. Therefore, they have asked to obtain instruction, lordship. There is a court order 6/1/2023 passed by the Honorable Justice Sosinta Malla Bujarboroy.
6/1.
6/1/2023, lordship.
6/1/23.
Yes. Presently petition.
Yes.
This order, lordship, honorable court may have relevant also. We have noticed that the husband of the petitioner was a participant in a special recruitment drive for physically disabled person pursuant to an advertisement dated so in respect of 134 identified vacancies where some appointments were made, but the husband of the petitioner was not appointed. Having accepted the illegality on the part of the department, is not appointed the husband of the petitioner as per the requirement. There was a direction passed by the court in the judgment and order dated 23/4/2005 in WPC number 1424/11 to give appointment to the husband of the petitioner, and the appointment dated 22/1/2019 was a result of such direction by the court. If the delay in appointment was because of an illegality by the department which has been judicially accepted in the judgment and order dated so writ petition number 1424/11, we request to respondent to explain how they can take advantage of their earlier illegality is not appointing the husband of the petitioner in due and appropriate time to deny the pension, that because of the aforesaid circumstances he has served for only above 5 months and not 1 year, the respondent to aforesaid query on the next day. But when he was directed to place the query of this court, lordship, but he tried to avoiding from his liability, lordship. Thereafter, lordship, the very next day, your lordship, honorable, another coordinate bench of this court, lordship, the observation was made out. Not only observation, there is a specific direction to release the pensionary benefit. If required consultation with the finance department in paragraph number 7, that is the distinctive direction.
So the finance,
Yes.
yes, Mr. Bortuzari. What do you make out of the order passed on 31/8?
My lord, so far as this writ petition is concerned, the first order passed by this honorable court is annexed as Annexure A. There, if lordship may be pleased to, my lord, come to page 22, because to me it appears this is the foundation of the petitioner's entire claim. A recruitment drive was, my lord, initiated in the year 2005-2006. Some anomalies were, my lord, noticed, and finally persons were not recruited. These are the persons, my lord, who suffers from physical disabilities. They moved this honorable court, seeking, my lord, an early appointment. Therefore, at page 21, if I may read it, my lord, page 21, order passed by this honorable court. Page 21, the last paragraph. In this case, what transpires is that a recruitment drive was carried out in the year 2005-06 to fill up 662 backlog vacancies of grade 3 and 4. These vacancies therefore obviously pertain to previous years, that is prior to the year 2005-6. Even in this drive, 134 of the backlog vacancies could not be filled up. It appears that since the year 2005-6, no review has been carried out by the state regarding identification of posts earmarked to be filled up by persons with disability or to update the list so prepared. In such circumstances, when admittedly petitioners could not be appointed because of anomalies in the selection process, particularly at the time of preparation of the state level select list, court is of the view that the ends of justice would be met if a direction is issued to the respondents to recruit the petitioners in the available vacancies after a recruitment drive is carried out in the year 2005-6 against vacancies that are available in different departments which are available with social welfare department. So this was, my lord, the direction to complete the recruitment drive. Lordship will kindly turn to the next page, my lord, page 23. Annexure B. Pursuant to this order, my lord, this order of appointment came to be issued by the Directorate of Employment and Craftsman Training. Dear Lordship, my lord, I am reading it. In pursuance of government approval as communicated by number so and so, and in pursuance of Honorable Guwahati High Court's order dated so and so, passed in so and so, the following persons with disabilities candidates are appointed as grade 3 in offices shown below in the scale of pay band so and so. Now, at serial number 3 of the table, my lord, the name of the deceased husband of the petitioner appears. Now, this was done in the year 2019. And for all purposes and intent, because this is the appointment order. Prior thereto, my lord, there was no appointment order. The petitioner, the deceased husband of the petitioner, or for that matter, my lord, the similarly situated persons.
And when did he expire?
He expired in the year, he expired in
July 2019.
2019 itself, after completing 6 months of service in pursuant to this appointment order. Now, in this appointment order, what I find it interesting, my lord, is that Lordship may be pleased to see the paragraph down below the table immediately. This has the approval of Finance SIU department. It's a regular appointment, my lord. The employee will be governed by the new pension rules. Employee will be governed by the new pension rule, because admittedly this appointment came to be effected on 22nd of January 2019. And by that time, my lord, the Lordship is aware that the cutoff date is, my lord, 1st of February 2005. Now, even if we presume, my lord, that the appointment process has started in the year 2005-6, but he was not in service. The petitioner's husband.
We understand, but what do you make out of the findings given by this court in the order dated 31/8/23? There is a categorical direction.
Yes.
And which was sought to be vacated.
My lord.
And it was sustained by dismissing the vacating petition. So in that view of the matter, there is already a finding
No, there
by
is
the court.
There is a finding by this honorable court, but my lord, so far as my lord, the pension is concerned, now pension will be, my lord, have to be calculated in terms of the new pension scheme, because this is the order. His own appointment letter states, my lord, because he has not put this appointment letter into challenge. He has accepted it.
No, you pay under the new pension rules. But
New
pay the
new pension rule for that period for which he has worked. Definitely he will be entitled.
You pay. Yes.
That, my lord, my learned colleague will be in a better position, because the finance is the, my lord, nodal agency for disbursal of, my lord, pensionary benefits under the new pension rules. Because he has worked for 6 months. Admittedly, he had worked for 6
For the
months.
period you have worked,
Yes.
they will give the pension, calculate on that basis.
As per the new pension scheme, Lordship,
Huh?
the notification as they have submitted, Lordship. The notification, Lordship, office memorandum, Lordship, in to their affidavit, Lordship, that is 31st of October 2017, Lordship, where he already done before this court, Lordship. But he suppress some relevant point, Lordship. So he did not mention.
Your appointment is on page 23, isn't it?
Yes, Your Lord.
So page 23 appointment order says that you'll abide by the new pension rules.
New pension scheme on basis of the notification dated 31st of 2017, Lordship. In such notification, Lordship, one another mentioned that, Lordship, that a government servant who dies while in service after having rendered not less than 7 years continuous service, the rate of family pension payable to the family shall be equal 50% of the pay, plus drawn or twice the family pension admissible under the norms rule. Whichever is less than the amount so admissible shall be
Which does not
payable.
apply to you. Does not
Not
apply to
applicable, my
you.
lord.
7 years.
Less than 7 years has continuous mentioned that in the last
Page
the
number.
30% of the last basic pay drawn in
Where is
case.
the page number? Which page number you reading?
Office memorandum dated 31st of October 2017. Lord. Memorandum.
45.
Office memorandum 31st of October 2017. Lord.
Number 3. Which one you are
Para number 3.
reading?
That is mentioned that the in case where the government servant has not has less than 7 years of continuous service
Para
before
3.
death, family pension in para number 3. In last column, family pension will be calculated at the rate of 30% of the basic pay drawn by the deceased employee. On other hand, in another para number 3, that is in this type of the case, the family pension equal 50% of the last pay drawn by the deceased employee.
We are not able to.
No, my lord.
You are reading from page number 46.
Yes, sir. Oh, yes. Lordship. The
My lord,
office memorandum dated 31st of October 2017.
Answer is to be found in that OM itself. Yes, sir. 45. my lord.
45.
Answer is to be found in, my lord, that OM dated 31st of October 2017. That's page 45. Lordship, kindly see, my lord, the references at the top. It is the second paragraph. I'm reading, my lord, the subject. Subject is revised comprehensive guidelines for family pension in respect of government servant who died in service pursuant to compassionate family pension scheme 2017. Then kindly see, my lord, the references. A, Assam service pension rules. B is, my lord, Assam service revision of payrolls. C, finance establishment department notification number so and so PPGOM. Now this has got to do everything with regard to the 1969 rules. Here is a case, my lord, where from their perusal of the appointment letter of the deceased husband of the petitioner inevitably goes to show, my lord, that the 1969 rules are not attracted to his case. Rather, my lord, the new pension scheme is attracted. So therefore, my lord, having worked for 6 months, he will not be left remediless.
Should not be calculated 6 months, Lordship. There is a direction and passed by this honorable division bench also, Lordship. The principal ground they have taken. With the direction of this honorable court, Lordship, previous occasion he was filing lead petition, Lordship, but not appointing
What
him.
order? What order has the division bench passed?
Division bench, Lordship, the finally, Lordship, the final lead appeal 235/2025, Lordship.
This has only dismissed it, saying that.
Dismissed, but saying that, Lordship, that in second para, Lordship, all these travels leads to the demise of the employee within a few months.
Narration of the facts.
Not direction of the.
Narration of the facts.
But Lordship, the first readable 48/2024,
It said that you are entitled to.
Lordship, wherein dismissed and asked to place their grievances before the honorable single judge. Accordingly, honorable single judge's one observation has already been made out.
What is your prayer? You want a pension, they are willing to give you a pension.
Yes.
Under the new rules.
As per the new rules,
Oh.
Lordship, in the notification
good.
31st of October.
That they are agreeable to do.
Yes, I'm entitled to get such benefit
You
on
get
basis
your
of the
benefit
earlier notification 31st
calculated
of.
on the basis of the services you've rendered.
If only calculation wages of service only 6 months, I am not entitled to get benefit. That is why, Lordship, the 2 occasions they have filed a writ appeal, Lordship, 2 occasions writ appeal has been dismissed. But my husband's service should be calculated from the date of
What do
initial
you say
appointment.
regarding the six months service?
6 months service, it will be calculated, my lord.
Not entitled to anything, Lordship. Hearing, Lordship, the Honorable Coordinate Bench of this Honorable Court, Lordship, order dated 5/6/2025, Lordship, wherein clear observation has been made out, Lordship, that he is entitled to get, she is entitled to get pension and benefit of her deceased husband.
He is covered under which memorandum? This 31st October?
No. He is covered under the new pension
New
rule.
pension rules.
New pension, because these OMs and office memorandums, notifications, everything, these circulars are issued to clarify the various incidences and exigencies arising out of my lord disbursement for pension under the 1969 rules. But the new pension is, my lord, clear. The one part is deducted from the employee, one part is contributed by the, it is just like provident fund. Then it is put to, my lord, securities. The interest accruing out of the securities along with the principal amount after deducting the statutory liabilities will be dispersed. It is as simple as that. And for that, my lord, the nodal agency is the Directorate of Accounts and Treasuries. For that reason, my lord, the administrative department concerned, that is the employer of the deceased husband of the petitioner, will have to make necessary proposal. They will have to move through proper channel. Because the appointment letter is accepted by the petitioner. Petitioner has not challenged this condition, my lord, appearing in the appointment letter, that the appointee will be governed by the new pension rules, meaning thereby he has accepted. Now, there is no point of resiling from that. And if he attempts to resile from then, my lord, then the principles of waiver, estoppel, and acquiescence will come into play. This is my respectful submission. Bare perusal of the
You are
appointment.
entitled to pension under the new pension rules.
But on basis of such notification, Lordship, 31st of October
That cannot
2017,
be.
Lordship.
How?
On basis of such
This-
notification,
if-
Lordship,
if-
entire adjudication has been carried out, Lordship.
No, if we press this notification, then you're not entitled to, it says minimum 1 year.
So minimum 1 year, that is the observation has already made out by this
How does it matter to you?
coordinate bench
How
of
does
this
it
court.
matter to you when we say that you are entitled to pension?
Yes,
You are entitled to pension, but under the new rules.
as per my appointment letter
as per your
concern, Your
appointment.
Lordship. As per my appointment letter concern.
Yes,
As per my appointment letter, Lordship.
yes,
He mentioned that.
yeah. As per your appointment letter, you're entitled to pension under the
This,
new pension.
this has yes, Lord, as per the new pension law, this has the approval of the finance SIU department by their UA number so and so dated so and so. The appointment will be governed by the new pension rule 2005 as communicated by the government in finance B department letter number so and so dated so and so. On basis of my appointment letter, Lordship, I am entitled to get the pension.
That's all.
That's all. But Lordship, only by consideration the nature of this case, Lordship, the previous coordinate bench of this honorable court has passed the continuing mandamus, Your Lordship.
Earlier orders did not say that you are entitled to pension under the old rules. That was not said. There was no direction to that.
No, there is a direction
That is
in
the
para number
direction that-
7, Lordship.
Huh?
In para number
Compassionate family pension.
In regards to the same Lordship, the Mr. Das has made submit before this court dated 36/2025 Lordship. Coordinate bench honorable court order self-reflected. There he made submit that he be given 2 weeks time to complete his instruction in the matter, Lordship. And when the matter was accordingly, he was granted time to complete his instruction, and the subsequent date when the matter was called upon before this honorable court, that is 19/7/2025 Lordship, he stated that the one writ appeal has been filed by him before the division bench, Lordship. Till then, Lordship, this matter he has stand adjourned, Lordship. Now, Lordship, lead table has been dismissed. Accordingly, this matter has been placed before this honorable court by as requirement of the earlier order dated 36/2025. He is bound to compliance as submission he made, Lordship. That is the court order, Lordship. This is not only passed by the order of the specific.
We are not saying he is not bound to comply. We are saying he is bound to comply, but
Yes,
under
he
the
is
provisions of
required to
new
make
pension rules.
submit before this court, Lordship.
Under the new
To
pension
compliance.
rules. Under the new pension rules. Because that is what is reflected in your appointment order.
Yes, your Lordship, as per the new pension, his government is bound to granted pension I benefit, Lordship. But Lordship, my matter may not be disposed of as because by considering the necessity of this fact, Lordship, of this matter, Lordship, as because the division bench itself clarified that this is the piquant fact, your Lordship. That is why, Lordship, the continuing mandamus has been issued by this honorable court. So may I please to read the continuing mandamus when issued, Lord?
No, continuing mandamus will be issued when there is a direction to comply with the order. The
Yes.
question is.
Yes,
that
there is a direction in
we are-
paragraph 7.
we are,
Of this.
we are putting a stop to this direction to be issued by concluding your writ petition, saying that you are entitled to pension in terms of the
Previous
findings.
occasion in the year of 2015,
Whatever
Lordship,
it
there
is,
is a
but-
direction was not carried out, Lordship.
Read with
So I
your
am
appointment.
otherwise, Lordship, I am not entitled to get any benefit, your Lord. So matter maybe continue, Lordship, and he was division bench was directed to him to pursue the honorable single judge order, Lord, honorable single judge order, Lordship. So he is bound to compliance, Lordship. There is a direction already passed in para number 7. Subsequent it says the one another IA Lordship which was filed by the government for alteration and modification, but the honorable single judge has in subsequent it says not modified the such order.
Heard,
The-
we are closing your matter. Heard, Mr. M. Sulkian, Learned Counsel. Also heard, Mr. S.P. Das appearing for the respondent 3. Anyone else appearing? Mr. R.K. Talukdar for so and so, Mr. C.K.S. Burga for so and so. Court has also heard Mr. R. Borpuzari.
The finance has
the
been
counsel
implemented.
For the finance department, a request made by this court.
Finance is a party.
He is a party.
Party.
Respondent number so and so. The writ petitioner before this court
Finance of whom
prayed for a direction for release of pensionary benefits, which he claims is entitled, have been released for the services rendered by her deceased husband for the period which he had rendered deceased husband, who was an employee of which department?
My lord, employment exchange, my lord, at Borpeta.
Employment exchange.
Borpeta.
Borpeta.
Great formal.
The late husband of the writ petitioner was a person with disability. Stop. And pursuant to his employment was posted as employment exchange Borpeta as in a grade 4 post. So the late husband of the writ petitioner, along with other similarly situated persons, had approached this court, putting a challenge to seeking a direction from this court for seeking a direction from the court, as their names were not reflected in the final select list for the recruitment process undertaken by the state. Pursuant to an advertisement dated 9/6/2005. Stop. The late husband of the writ petitioner was a petitioner in WPC 1424 of 2011. Stop. This writ petition, along with another connected matter, came to be heard and disposed of by order of a coordinate bench on 23/4/2015. Stop. The coordinate bench concluded that The recruitment drive was carried out in the year 2005 and 6 to fill up 662 backlog vacancies of grade 3 and 4. These vacancies, therefore, pertain to previous years prior to the year 2005 and 6. So, however, since the year 2005-6, no review was carried out by the state regarding identification of posts earmarked to be filled by persons with disability or to update the list so prepared. The coordinate bench accepted the submissions made before the court that there were certain anomalies found in the select list, because of which the late husband of the writ petitioner and other similarly situated persons could not be appointed. The vacancies which were sought to be filled up under the recruitment drive for the year 2005 and 6. Stop. Accordingly, the coordinate bench ordered that these vacancies which are available in different departments and for filling up by persons with disabilities, and the list of such persons being available with the social welfare department, a direction was issued to carry out recruitment to these vacancies available by making, after proper verification. Stop. All administrative departments were directed to cooperate with the social welfare department in ensuring that the petitioners were suitably accommodated against the identified posts in the respective department. Stop. The social welfare department, being the nodal department, was directed to verify the position of the petitioners vis-a-vis the selection process and proceed with their appointment in terms of their position. Stop. The above exercise was directed to be carried out within a period of 4 months from the date of receipt of a certified copy of this order. So, the said writ petition attained, the order passed by the coordinate bench in the said writ petition attained finality as no appeal was preferred. Subsequently, the present writ petition approached this court by filing the present proceedings, praying for a direction on release of pensionary benefits payable to her deceased husband, who in the meantime expired. Stop. The coordinate bench, while entertaining the present writ petition, by order dated 31/8/2023, issued the following direction, para 7 extract. So, being aggrieved, the petitioner approached this, the respondent filed a writ appeal, being writ appeal 48/2024, which also came to be disposed of by the following order, extract. So, subsequent thereto, the state filed an application seeking vacation of the order. This vacating petition also came to be rejected. Vacation of the order dated 31/8. This vacating petition came to be rejected by order dated 5/6/2025.
My lord, it does, my lord. Prior to that, my lord, he filed another petition at WPC number 6121/2021, my lord. That may also be recorded, my lord.
What happened to that?
But that was disposed of, my lord. If you lordship see the page number given.
Disposed of for what?
WBC number 6121. Please notice that.
This interlocutory application was rejected by the
Six
court
one
and
one.
bench. Relevant
Next,
matters are
yeah.
expected to be
Page number 33.
34. Huh?
Page number 33 also.
Writ appeal 33.
Madam, writ petition, madam.
Writ
petition.
petition.
Madam. Annexed by him, madam.
Where is that order?
At page 33, madam.
Page 33.
Yes, madam.
What happened there?
Madam.
Dispose of with a direction. Giving to the petitioner.
Paragraph
to-
5, madam. 4 and 5, madam.
Five, it's really five lordship. Writ petition is dismissed with liberty being given to the petitioner to approach the respondent with regard to her claim for payment of pension or pensionary benefit as per the new contributory
Yes.
pension scheme.
Yes, you want to get it.
এই আগৰ যিটো the first writ petition which attained finality তাৰপিছত লগাব petitioner again approached this court by filing PC 6121 of 2021 claiming for pension. Under the new contributory pension scheme. So this writ petition came to be closed by order dated 22/12/2021. By the following order, page number 34, extract. Stop. Para. The petitioner before this court is seeks to urge before the court that in view of the categorical finding arrived at by the coordinate bench by the order dated 31/8/2023 and the subsequent order passed in the IA number so and so. The respondents are duty bound to carry out the orders. And against these orders, writ appeals being filed, which also came to be disposed of by the writ appeal number so and so, order dated so and so, who writ appeal. So therefore, the petitioners are duty bound to grant pensionary benefits. Respondents. Stop. Para. Mr. R. Borkuzari, Learned Standing Counsel for the Finance Department, submits that the petitioner is bound by the appointment order, which is at page Annexure B, page 23, which was issued on 22nd of January 2019. So by the said order, it is clearly mentioned that the petitioner will submit undertaking at the time of joining that they will abide by the new pension rules. Therefore, under the new pension rules, petitioner's pension can be worked out on the basis of such proposals being submitted by the administrative department, and thereafter the necessary pensionary benefits can be released. Better. Mr. S.P. Das, counsel for the respondent in the skill development department, as well as the others, counsel representing the respondents, also submit that the petitioner would be entitled to the petitioner's claim would be worked out under the new pension rules. Better. Having heard counsel for parties and upon perusal of the various orders, it is seen that by the appointment order dated 22nd of January 2019, petitioner was appointed under the Directorate of Employment and Craft Training. That appointment order clearly reflects that the petitioners will have to submit an undertaking at the time of joining that they will abide by the new pension rules. Stop. Did you submit that undertaking?
Your lordship, but my service period, husband service period should be considered in prior lordship. As because there is a specific direction passed by the honorable.
The petitioner's husband duly joined in the same post and also submitted his declaration to be granted, governed by the new pension rules. This is also reflected in the order passed by the coordinate bench in WPC 6121 of 2021, whereby the claim before the writ petitioner was to consider the petitioner eligible for pension and pensionary benefits in terms of the new contributory pension scheme, which is the new pension scheme. Stop. The writ petition, although dismissed, liberty was granted to approach the respondents towards the claim for the pension and pensionary benefits under the new contributory pension scheme. Stop. In the present proceedings also, at paragraph 10, there is an averment made by the writ petitioner that the petitioner has received the pensionary benefit under the NPS, under the new pension scheme rule, but not the original pension scheme. So, under such circumstances, the petitioner is before this court praying for release of or consideration of pensionary benefits under the old pension scheme on the basis of the contention raised that had the petitioner been appointed in time, in pursuance to the directions contained in the order dated so and so passed in WPC 1424 of 2011, the petitioner's late husband would have been appointed in terms of the same order, and appropriate pension orders would have been granted under the old pension scheme. Stop. The further contention is that that the coordinate bench by order dated 31/8/2023 and the subsequent order dated 5/6/2025 has reiterated the claim of the pension payable to the writ petitioner under the compassion, or what is that pension scheme?
That is, my lord, the compassionate family pension. It is a different scheme, my lord.
Compassionate family pension scheme. So,
And the undertaking, my lord, appears at page 29, my lord. I'm sorry, my lord, I should have pointed out, my lord. Page 29 of the writ petition, annexer G. Annexer G.
the new pension was effective from
My lord, 1st of February 2005. And my lord, earlier round of litigation also, this honorable court has adopted a
considered
finding.
the submissions made by the counsel for the parties. It is seen that the claim of the petitioner is premised on the orders passed earlier by the coordinate bench by the order dated 23/4/2015, passed in WPC 1424 of 2011, read with the order dated 31/8/2023, passed in the present proceedings, and order dated 5/6/25, passed in IA number 1350 of 24 within brackets is disposed. Stop. The petitioner's attempt to interpret these orders that he is entitled to pension under the old pension rules on the face of it is not acceptable for this simple reason that the direction of the court in WPC 1424 of 2011 and another writ petition was issued on 23/4/2015 Stop. The new pension scheme was brought into effect on 1/2/2005. Stop. Therefore, on the date when the direction of this court was issued on 23/4/2015, passed in WPC 1424 of 2011, the new pension scheme was already in force. Stop. The appointment order given to the writ petitioner by the order dated 22nd of January 2019 also clearly reflects that the petitioner will be governed by the new pension rules. And a declaration to that effect is required to be given by the petitioner, which the petitioner has given in page number
My lord, page number 29, Annexure G. That is the
29,
undertaking,
which is enclosed to the writ petition as Annexure G.
my lord.
Stop. Under such circumstances, the interpretation sought to be projected before the court that the petitioner is otherwise entitled to be governed by the earlier pension scheme is ex officio not acceptable, inasmuch as the new pension scheme was brought into effect from 1/2/2005, and the claim of the writ petitioner stood crystallized with effect from the orders passed by this court by the order dated 23/4/2015, passed in WPC 1424 of 2011 and other connected matters, writ petition. That apart, the petitioner has earlier approached this court by filing WPC 6121 of 2021, wherein in the recital of the order itself passed dismissing the writ petition, it is clear that the petitioner's claim before the court is for grant of pension and pensionary benefits under the new contributory pension scheme. Stop. In view of all the above, the court does not find any merit in the writ petition, save and except to issue a direction to the respondents that the claim of pensionary benefits, if any, yet to be released to the writ petitioner under the new pension scheme and to be calculated appropriately by the administrative department. The same shall be released expeditiously without any further delay. The administrative department, namely, which department? Directorate of Employment.
Yes, ma'am.
Huh? Directorate of Employment and Craftsman Training, Guwahati, Rihabari, will examine the case of the petitioner and pass necessary orders quantifying any pensionary benefits under the new pension scheme yet to be released to the writ petitioner, and if so, the same necessary proposals thereto shall be placed by the authority for release of such pensionary benefits. Stop. In the event it is found that the benefits due to the writ petitioner has already been released, then an order to that effect shall also be made. Any orders passed by the respondent as directed, copies thereof shall be served on the writ petitioner. The entire exercise be completed within a period of 60 days from the date of receipt of a certified copy of this order. Disposed. In view of the order passed today, contempt petition.
Late with the lordship. My lord, I have taken consent my senior, item number 7 and 8, my lord. My item is 8, my lord.
You mentioned in the morning, what is this new
sorry,
culture of mentioning in the second half?
My lord, I'm not feeling good, my lord.
You're not feeling good, you ask somebody to remain. We'll accommodate you, inform the court master.
Yes, my lord.
Yeah?
And I have taken also consent from my senior, right?
7, 8.
7, 8, do so. Any
7 and 8.
next week, anytime I'm ready, my lord.
Mr. Roy Chaudhary,
My lord, because you
every
were
time
not
you appear, somebody feels unwell.
my lord, in number 8,
Number 7, my lord, the councils are quite agile to do the case, my lord, but he is saying that similar matters.
7 and 8 on the request.
Well, not
item-
7 and-
Item 8 on the
well, only
request of Mr. Deka stands deferred to be listed after 1
on
week.
13th, my lord, I have
13,
some urgency.
all right, 13.
Some
Since
urgency.
It is connected with item 7, the writ petition so and so in item 7 is also listed. 7 and 8 on 13.
Yeah, flawless, my lord.
Yes.
May it please your lordship. Lordship, we have just received the affidavit in opposition filed by the state. So we need 2 weeks time to file our reply, madam.
Mr. SP Sharma, counsel for the petitioner.
Lordship,
please
1 week
comment.
time may be granted, Lordship.
Huh?
I am appearing for the respondent number 5, Lordship.
Huh.
Lordship, we have some urgency, Lordship. We have filed an application praying for modification of the interim order.
Yes, some affidavit has been filed today, is entitled to some time.
Not today, not today, 2 days before, we have 2 days before this.
Right. The matter stands deferred on the request made by Mr. SP Sharma. Item number
5, madam.
5. On the ground that an affidavit has been filed for which he seeks to file reply. List again on 27th.
Much obliged. I have interim order to be completed.
Interim order partially will continue. Mr.
You host.
You goes for
Respondent number 5, Lordship.
respondent 5, Mr. A. Ghosh. For Mr. K. Kaur is appearing for the PNRD department.
For the state as an additional.
For the state.
Much obliged, madam.
Item 6.
Lordship, in the last occasion, Lordship.
Yes.
Last occasion, Lordship, regarding the scrutiny, Lordship, we did the scrutiny, the District Commissioner Halakandi did the scrutiny and it sent to the AIDC, Lordship, for their
So that we are not
selection.
asking, we are
Yes.
asking you, how have you categorized grade 3 and grade 4?
Yeah, that was categorized by the AIDC, Lordship.
Who's for AIDC?
Yes, Your Lordship.
What do you say?
Your Lordship, we need some time to read.
Third counsel for the parties, Mr. J.K. Goswami, additional senior government advocate on instructions, written instructions received from the respondent submits that the screening committee constituted by as per the MOU between the government and the association of the HPC Limited forwarded its recommendation to the managing director AIDC. So, the screening committee was only required to verify the original documents of these employees working under the HPC at the relevant point in time. The entire selection process, however, was conducted by the AIDC. The learned council therefore submits that it is the AIDC would be the appropriate authority to apprise the court as to how the elections were conducted. MS.
Emrukha.
So and so appearing for AIDC.
AIDC.
Submits that she would like to complete her instructions and prays for 2 weeks' time. List again after 2 weeks. List recording.
Lords.
Any convenient date may be given. My lord, any convenient date may be given.
5th of December. Obliged on 5th of December.
Item 9 and 10.
Yeah, Lordship, Mr. B. Pulkaster is on leg. It may be taken after some time.
There is no after some time we are taking up the matter, yes.
Next,
I'm for the respondent ONGC in both the matters. Here the issue is,
They're
the-
asking for some time, are you
my lord,
able to that?
or Lordship may fix another date because I have a bad matter which will be called at the moment.
All right, right. On the request made on behalf of Mr. B. Pulkaister, matter stands request to be listed again on 5th of December. 5th of December.
Fine.
deeply obliged.
I'm for respondent ONGC in both the matters.
Mr. S. Chakraborty appears for respondent. ONGC
ONGC in both the matters.
and
I'm 41, 3, 4.
111.
MS so appears for Mr. Roy is appeared. Mr. S. S. Roy, and at CGC appears for respondent number 1. List on 5th.
Deeply obliged.
11.
My lord, the instant writ application is arising out of the from the first WBC case, the third litigation, my lord. WBC, the annexer 1, that is the 3039/2016 WBC. The case has been was filed by the petitioner for regularizing his leave period on medical ground and to release all the pensionary benefit with effect from arrear salary from March 2008 till the date of filing. And accordingly, my lord, this judgment, after hearing both the parties, honorable court was pleased to pass on her. Lordship, kindly turn to page number 90 to 95.
What is your grievance here? What are you praying for?
My lord, my now in the instant case, my lord, I have assailed the expert inquiry report. Expert inquiry report, and that was in violation of the judgment and order dated 12/6/2017 in first WBC case, and also to release all the arrear salary with effect from March 2008.
Where is that order of the court? Page number?
90 to 92.
90 to 95, my lord. The relevant portion of the candidates. Relevant portion, Lordship, kindly, from paragraph from page number 92, my lord, paragraph 4. I want to draw the attention to regarding some appearing for the writ petitioner, Mr. S. Sharma, the learned counsel, has submitted that the petitioner has not received his salary since the month of March 2008 till death. He submits that although the petitioner submitted leave applications from time to time for his medical treatment, the respondents have failed to regularize his leave period, and as a result, he has been denied his salary. The learned counsel further submits that when the petitioner joined his post after his
So
medical
the directions were issued at page 95. Page 95.
Page 95, my lord, that is the final
Direction.
Yes, my lord. Paragraph 7.
What happened
From
after that?
94, my lord.
Then what happened?
From my yes, my lord. Paragraph. That's why I have submitted, my lord. That I was not allowed to put signatures on in attendance register, and that's why I have submitted. And honorable court has allowed me to put signature in attendance directly. That's one. Now, my lord, paragraph 7. I have considered the submissions advanced by the learned counsel for the parties.
We have seen the directions, Mr. Sharma. You don't have to
Yes,
read
my
it.
lord.
We are
Direction
asking
number
you.
1, my lord, the respondent department will proceed with the inquiry proceedings from the stage of the show cause notice dated 14/8/2009
All right.
issued to the writ petitioner, and the writ petitioner shall submit his reply to the same afresh in terms of the notice within 10 days, and the petitioner shall also be permitted to examine and inspect all documents proposed to be relied upon in the inquiry proceedings. The petitioner shall join his post immediately, and the respondent authorities shall examine the admitted dues pending against his salary. He shall be entitled to his salary otherwise from the date of his joining to his post. Considering the fact that the petitioner is due to superannuate in the month of December 2017, The departmental authorities shall conduct the inquiry proceedings as expeditiously as possible and within the outer limit of 3 months. The inquiry proceedings shall commence immediately from the date of receipt of a certified copy of this order. It is also hereby provided that the petitioner will be allowed to put his signature in attendance register and he in turn shall give full cooperation in the inquiry proceeding. My lord, this is the judgment passed by the Honorable Court. Now, my lord, they did not conduct any inquiry, even after this is the second opportunity was given to them. Now, in the meantime, 3 months have been elapsed. Just before retirement, we are compelled to prefer the contempt case number 529 to 2017. And after hearing Honorable Court, now during the pendency of the contempt case, I will come later on. During the pendency of the contempt case, suddenly, my lord, the annexer 3, my lord, that is the impugned expertise inquiry report, page 100 to 110, my lord. My lord, this is the inquiry report, along with a letter issued by the chief engineer to the petitioner that annexer 3 and annexer 4, my lord, is the letter. That is annexer 4, my lord, 111. By this letter, this inquiry report was issued, submitted to the petitioner. The inquiry report, when it was prepared, there is no mention about the date. No date is prepared. No date is mentioned.
You were not given a copy of the inquiry report.
We have never received inquiry report during my after retirement. There is nothing, no report has been submitted. Only in 2018, my lord, by this letter, annexer 4. Annexer 4, my lord, page 111. For the first time, I have received this letter. I was asked to submit my so-called reply against this inquiry.
This letter encloses the inquiry report was forwarded by this letter.
Along with this letter.
Along with this letter. Then what happened after that?
Thereafter, my lord, what happened? Honorable Court has asked through various orders in the contempt case
No, after you have received the inquiry report,
this is the inquiry one.
did you file an appeal?
I have submitted our reply. Answer. Although it is an expertise inquiry report, my lord, I have submitted my reply by the next sir. 35, page number 233.
Yes, 233.
Page
Then
233.
what happened after that? After that, what happened?
Then, my lord, they remain silent regarding my admitted dues they have not released. And after various orders, an honorable court also had asked them to submit the date on which the inquiry report was prepared. There are 3 orders passed by this honorable court in contempt case. Then ultimately they have stated that when this inquiry report was prepared, they could not submit the records. That order is also here available, my lord. In annexer 49.
No, after the reply, what happened?
After the reply, my lord, then the honorable court had passed an order on annexer 46, annexer 45, page 288 in contempt case 27/6/2019. Let's kindly turn to page 288.
Yes.
288.
Yes.
Now this is the order in contempt case, my lord. This is the matter. Leave this matter again on 25/7/2005, failing which the concerned respondent will appear before this honorable court. Because from the previous page number 280 to 89.
No, this inquiry report is pursuant to a charge sheet. Show cause issued.
Yes.
Show cause issued.
So cause notice, inquiry report No,
Disciplinary proceedings.
the inquiry report, my lord, was submitted to me.
Why was the inquiry conducted?
Inquiry was conducted, there is no mention about the dates. Expert inquiry report.
Did you receive any show cause notice?
So called notice, yes, my lord, I have received, no, so called, yes, but so called notice I have received, my
You are
lord.
not prepared, Mr. Sharma.
Yes,
Wasting
my lord,
time.
I have received, then I have given the
No,
reply
no,
also.
come back prepared in the matter.
My lord, I have given the reply. I have
Not
given
like
the
this,
reply.
Mr. Sharma, this is not like this. You want an admission hearing, you are unable to answer the questions.
No,
of the
no,
court.
yes, I'll satisfy your lordship. I have given the reply. I
We are
just,
kindly listen to the queries of the court. Was there a show cause notice issued?
so called notice, issued after submitting the reply, after submitting the inquiry report. Along with the annexer 24.
Who's from the department?
Lordship, annexer 24.
Which department is this?
Public health engineering.
Where is public health? Yes, come and explain what are you doing?
Annexer 24, my lord.
Yes, tell us.
Lordship, my sincere apologies. D. Gogoi was handling this case, Your Lordship. So he asked me to just seek or
See the
rather,
proceedings and report. You are a counsel appearing on behalf of the department. This is not the submission expected. Once you appear before the court, you are expected to at least go through the briefs and understand what is the matter about.
I don't have the brief, Your Lordship.
Is it our fault that
No,
you don't
no,
have the
no.
brief?
No, Your Lordship.
Where is Mr. Gogoi? Is he the only
Lordship,
standing counsel?
He had to
Is
leave urgently.
he the only standing counsel for the department? There is no other standing counsel.
R.R. Gogoi is there, Your Lordship. He's in the midst of a hearing.
So are we supposed to wait until your standing counsels are free to address the court? You call him or you apprise the court. This is no way of conducting proceedings in court. That as and when it appears to you, you will come and appear in the court. We are calling it after 10 minutes.
Lordship, I'll call Mr. R.R.
Wait for 10 minutes.
Yes, my lord.
Or we are passing strictures against the department.
I'll just inform him, Your Lordship. Apologies.
Yes, Mr. Soisin.
In this case, my lord, after my lord, submission of the charge sheet, I have submitted my written statement. And thereafter, I was never called for my lord participating in the my lord proceeding in gross violation of the Rule 9. And thereafter, order of termination has been passed.
Where is your show cause?
My lord will find this so cause, my lord. Page 42 is the my lord, initial my lord, page 42.
Yes.
Page 43, I have submitted by reply.
Then?
And thereafter, my lord, charge sheet has been, my lord, issued at page 45.
40?
5. Oh, my lord, 49, my lord, 49. Is the so called. Then I have submitted my lord, written statement against this, my lord, page 50. Then your lordship will find I was never called for my lord, participating in the my lord, proceeding at page 53. Notices have been issued to different witnesses who were called for my lord, to appear before the my lord, disciplinary my lord, committee.
Yes.
Page 57.
Yes.
I have only been marked, lordship will find at the below. Diganta Borwa, that is me, my lord. It's only marked, but so far as the person, my lord, by this notice has been, my lord, asked is the witness number 4, Padmeswar Buragohain. Similar notices, my lord, I have issued, my lord, been issued to different other witnesses, page 58, 59, 60, 61, 62. These are all my notices to the different witnesses. All the notices only marked to me, my lord. And thereafter, my lord, the order, my lord, at page 63 has been passed.
They filed an affidavit saying that you are informed about the dates, but you have neglected.
They have filed, but my lord, they have not, my lord, controverted my statement.
Where are the records?
Paragraph 9.
Records is available here, Lordship.
Hmm?
Record is here.
Yes, show us how you have communicated. What about appeals? Did you file any appeals?
Lord,
Yes, appeal dismissed.
appeal, I have, my lord, page 64, I have filed. And then they have, after the, my lord, filing of the appeal, they realized, my lord, there is a mistake in the, my lord, order dated 10 January 2024, page 63. They have passed again another order at page, my lord, 78, after filing of the appeal.
What is the appellate? Where is the appellate order?
Appellate order, page 79. my lord. From here itself, my lord, it clears that I have never been called from it. It's a long one. Lordship may come to my lord, page 81. During examination and cross-examination of the documentary evidences and comments by DC Sipsagar Bhai letter dated 12/7/2000 as per Rule 22 Assam Survey, the appellant was provided with due opportunity to make his representation by letter dated 16/10/2023.
So your ground is that the inquiry proceeded without giving you an opportunity.
Opportunity, my lord.
You did not appear before the.
No, my lord. Gross violation of, my lord, the Rule 9, my lord. Nor even the inquiry report was given to me. And on top of that, my
How
lord,
did you file the appeal?
my lord,
How have you filed the appeal?
file, my lord, because the order of dismissal was served on me.
Without getting an inquiry report?
Nothing, my lord.
Yes, Mr. Counsel.
Thing is that in our affidavit, we have this thing, we have stated that
Records.
record is here, Lordship. In the records, Lordship, at page number, this Lordship dated 16/10/23, that is the charges that we have filed, that wasn't communicated to him.
Yes.
Secondly, Lordship, what is his contention? Basically, the notices served before the hearing, the notices are not, I am finding in the record, Lordship. Otherwise, Lordship, we have stated that the charges were being communicated to him. And
Inquiry report. Inquiry report, proceedings.
yes, Lordship, yes, inquiry report.
Cross-examination.
Lordship, this is the, what I am saying is the Lordship 5 January 2024 is submission of report of departmental proceeding against Diganta Bora.
That is the report.
That is the report, Lordship.
Prior to the report, during the inquiry proceeding, was he given an opportunity to participate? Was he informed that on so and so date, hearing is fixed?
That is in our affidavit, Lordship. That is in our
How have
affidavit.
you
Lordship.
prepared the affidavit? From the records only?
For Lordship, definitely.
So which records did you rely on while filing the affidavit?
The record in connection with the departmental proceeding, Lordship.
So show us where have you initiated the communication reports?
Lordship, that we will find in the finding, Lordship, in the finding of the this thing. Lordship, I may be allowed to read the finding, Lordship. That
There must be a proceeding book available.
Yes. So, Lordship, I may be allowed to read the finding. Everything is clear here from the
Finding from where?
finding in connection with the departmental proceeding from the record, Lordship.
Finding in the order.
Finding during the proceeding of the during the proceeding, Lordship, of the in connection with the departmental proceeding based on the report, Lordship, inquiry. Because before the finding, there was those.
The counsel, you have not understood what we want to tell you. The inquiry presupposes the inquiry. Is it a preliminary inquiry or a?
No.
No, no.
Final inquiry.
Fine.
It's a final inquiry.
So-
There were list of witnesses, lordship.
Ah.
Those witnesses will be cross-examined. After that, lordship, the issues, lordship, the reasoning on the issues and the finding is being laid down there, lordship.
Right, so on the, how many days the inquiry proceeded?
It appears 3 days. 13/11/23, 1/12/23, 14/12/2023.
Was his presence recorded? Did he participate? Was
No,
he-
see, I may be allowed to read the finding, lordship, in the. It's also two-page finding, lordship.
Finding on what?
Finding on the charges and reasons thereof are reasons, lordship.
This
On
is
the
the-
findings and reasons, lordship.
Findings on the findings pursuant to the inquiry.
Lordship.
We are not asking you that, we are asking you prior to the findings, was he given an opportunity to participate?
One thing is, lordship, the affidavit in our hand, lordship. Secondly, lordship, lordship, the order of 5 July 2024, this order passed by the Deputy Commissioner was in the DP initiated, and whereas Sri Bora was given opportunity to show cause against allegation level against him, and whereas the show cause reply was not found satisfactory, therefore an inquiry officer and also a presenting officer were appointed to conduct the departmental inquiry under Rule 94 of Assam Service Disciplinary Appeal Rules. Produce the reports of the inquiry officer and seal all the documents attached with the report are found to be substantial for the findings of the inquiry. And whereas the understand after careful examination of the report, satisfied with the findings of the inquiry officer, that the matter relates to misuse of official position, cause harassment to the citizens, and is deplorable in any society, comes to a conclusion that Diganta Bora land record assistant, so also unfit for containing government service. Now, therefore, in pursuance of Rule 7, Rule 7, sub Rule 7 of Assam Service Disciplinary Appeal Rules, read with provision Article 311 of the Constitution. Lordship, the Deputy Commissioner Disciplinary.
That is the conclusion.
But here, Lordship, we have in the order it has been present, Lordship. Lordship, Sri Bora was given opportunity to show cause
On
against.
what basis have you given the opportunity? Is it by knowledge? Is it by record?
Lordship, then Lordship, I may be allowed to get the copies of the notice, Lordship, that was in served to him.
So who is stopping you?
Sir,
You are
because-
saying that your affidavit has stated.
Yeah.
Affidavit is
Then-
not
then
given.
maybe it may be from the twist is by knowledge or by record. It may be stated basically on the record on knowledge, Lordship. So I may be allowed to get the copies of the notices, Lordship.
Lordship, may kindly see my
No,
paragraph
we are
9.
not asking you notices. We are saying a proceeding has to be maintained that so and so is a date fix, who has come, whether his presence is recorded.
Lordship,
This is
understand,
sufficient.
Lordship, because before every hearing, Lordship, the notices are to be served. And if he does not present and order has to be there, then it proceeded ex parte or
Where
something.
is that record?
Lordship, that the copies of the notices that we have served to him, Lordship, I may be allowed to get. And if anything in that regard, that instruction will have Lordship.
Only see my paragraph 9 of my writ petition. I have specifically stated, and this has not been denied.
Let him get the records.
The records are here, my lord.
No,
And the other day also record was here, my lord, and in day this situation has
Are
arisen.
these the only records or some other records are there?
The record we asked for, they only provided this record, Lordship, but the record they maintained. But
They are the records, then we are interfering, we are allowing the petition.
because Lordship, one thing another I have noticed, Lordship, in this record, Lordship, the office note is not here. Otherwise, all the records they have a.
You are the government council, you are addressing the court.
No, Lordship, that's all, Lordship. I have to address whatever material I have before my hand, Lordship.
No, I completely disagree with this submission. You are an officer of the court, you will address whatever is relevant to the issue.
Lordship, I'll definitely,
You are
I'll
not a-
definitely.
you can't behave like a post office, whatever
No, no,
comes
Lordship.
to you, you place it.
Lordship, I'll definitely, Lordship, keep it up to your Lordship. I may be allowed to get whatever, Lordship.
Heard Mr. P.J. Soikia, learned senior counsel assisted by Mr. P. Bordoloi and Mr. C.K.S. Borua, learned government advocate appearing for the DC.
Yes, Lordship. The Deputy Commissioner Sipsagar.
Which district?
Sipsagar, Lordship.
Sipsagar and Mr. J. Hendy for repeat. The matter pertains to a challenge made to the inquiry proceedings conducted by the department, by the Deputy Commissioner against the Commissioner who was serving as land record assistant under in the district of Sipsagar. Stop. Pursuant to the inquiry proceedings, the petitioner was terminated from service. The appeal preferred, departmental appeal preferred also stood dismissed. It is the submission of the senior counsel that the inquiry conducted was an ex-party inquiry and no opportunity of hearing is granted to the petitioner. He was not allowed to cross-examine the witnesses. And as a consequence, the inquiry proceedings, the orders passed by the disciplinary authority as well as by the appellate authority calls for interference by this court. By contra, Mr. C.K.S. Borua, appearing for the respondent Deputy Commissioner Sipsagar, submits that the department has contested the case of the petitioner by filing an affidavit wherein there is an averment that petitioner was intimated of during the course of the inquiry. However, he neglected to participate, and as a consequence thereof, the inquiry concluded with the findings holding that the petitioner is guilty of the charges framed. Stop. The disciplinary authority concurred with the findings and passed the order of termination. Compulsory. What is that?
Termination.
Termination. He therefore submits that there is no infirmity in the inquiry proceedings or in the orders passed by the disciplinary authority, and therefore the petition being devoid of merit should be dismissed. Although earlier orders passed by the court directed the respondents to produce the relevant records, and records are stated to have been received by the learned government advocate. However, the learned government advocate on perusal of the record submits that certain other instructions are required in respect of the participation of the petitioner in the inquiry proceedings and of rigor, the notices that were served on the petitioner during the course of the inquiry. So these instructions are not available in the record furnished. He therefore prays for further 2 weeks' time to complete his instructions and produce the relevant records if so advised. List again on 4th December.
It's on the verge of retirement, only 2 years left.
Only
1.5 years left.
still good enough. 4th December is good enough.
Yes, very well.
Well, the entire records, whatever they want to produce,
the-
because evidences, etc., all these things are
The
there. Should not be on the piecemeal.
government advocate is permitted to complete his instructions and produce all relevant records pertaining to the instant inquiry proceedings. For perusal of the code if the need so arises. Stop. It is made clear that if the records are not produced, court will proceed to hear the matter on the basis of the materials available before the court.
Merciless.
So we keep this matter as a part of also. Lakshmi has already had that.
Timing item 11.
Oh, let's.
Yes. What has happened here?
Lordship, his show cause was issued in the year 2009, 14/8/2009. Thereafter, he filed a writ petition, sir, hearing number writ petition 3039, where there were specific directions to be complied with. Since there was no compilation of the direction, a contempt case was filed, 529/2017, and that has been disposed of, the Lordship. Now, if your Lordship may take our affidavit in opposition, Lordship, which we have filed.
According to the petitioner, there was no inquiry conducted.
Inquiry conducted, Lordship. He himself have an exact inquiry report in the writ petition.
He says the inquiry report is furnished, asking him to submit show cause or reply on the inquiry report, but in the inquiry proceedings, he was not
Right, and
called upon to participate. Is that your case, Mr. Sharma? You did not participate in the inquiries.
No, my lord, I was not asked to appear. Behind my back, everything has been done.
Yes.
Because, my lord, just I want to make it clear, my lord, because during my service period, I had taken leave on medical ground only for a limited period of 1 year, because my right eye was directly hit by due to the negligence on the part of the department, and as a result of it, I lost the vision of my right eye. In graduation list, my position is number 1. Now, what happened, my lord? I was working very sincerely and with dedication. Now, what happened, my lord? My right eye was hit by due to the negligence. While I was working in the water plant in Panbazar, then due to the negligence on the part of the department, a electrical flash directly hit my right eye. And then, as a result of 5 times operation has been taken place, and after operation, my lord, I had lost the vision of my right eye. Now, why I had to take leave on medical ground? That's why I am submitted. Then it is already decided by this honorable court. And then, my lord, after 5 times operation, I had lost the vision of my right eye. And subsequently, my lord, I have been suffering from bronchial asthma, serious bronchial asthma. For that reason, my lord.
Did you receive the notice from the department that inquiry is underway, you are required to participate?
No, my lord. No, my lord, that after passing the judgment, they have after 1 year, they have started an inquiry behind my back. And then along with the inquiry, a letter was issued to me to submit my reply for the first time in 2018.
Get your records. We'll have to see your records.
Very well. And another very important, my lord, as per the expert inquiry report, they had for the first time after 9 years, a very nominal amount of rupees 7,20,000 was sanctioned. And out of that, 51,000 is deducted arbitrarily.
You are not receiving pension?
I have not received the pension.
Provisional? Provisional pension?
No. Provisional pension, yes. Provisional pension was, I had received as per direction of the contempt court. But suddenly they have stopped, my lord, from September. Because a notification was issued. As per that notification, they cannot, in compliance with the contempt case order, they were directed to release the provisional pension. Suddenly they have stopped with effect from September 7. My lord, this is the kindly see. This is the notification. This notification is not applicable in our case. Whenever after 6 years they can stop the provisional pension as per notification, but subject to the condition that approval that the restricted. Here it is stated that in respect of the pensioners facing departmental or judicial proceedings, the existing rules shall continue to apply. That means, my lord, as per the pensionary rule 22, they should continue the provisional pension until and unless the regular pension is given to me. And that's why, my lord, that should be continued, my lord. How the family is going on.
My lord, as per our affidavit, clearly mentioned in page number 331 that PPO had already been issued. PPO number 926311307667, that is on 13 August 2023 itself we had. ECRG only left, PPO have issued. ECRG looks a house building advance was taken by him. That is not been settled. That is why we have that was it. But PPO has been issued. He is getting regular pension. I think. We have issued PPO.
No,
But he says he.
No, no, Lord, sir, I have
But my
selected.
record says this.
You
affidavit
get
has- records and find out when was the last amount received.
Release?
That will say by,
Fine,
that
fine,
will
it
be
was-
by Treasury official. Because we sent to Treasury official.
No,
These all record payment regarding payment. is to be
Lord, sir,
sent
I
to
want to make
Treasury.
it clear regarding my learned friend, what he has said. I had challenged this is first cause of action. That's why I had to prefer this third litigation because my lord, they had decided they are going to decide provisional pension as my regular monthly pension. Provisional pension at the rate of 18,000 they are paying, but that is not my regular monthly pension. And that's why I have calculated, my lord, 5 table 1, 2, 3, 4, and 5 in my categorically we had mentioned here. But now they are going to pay provisional pension at the regular monthly pension. That's why I have challenged, my lord. Annexer 6 and 7.
That is the
Oh, sorry, Annexer 7 and
Then
8,
we'll
my
have
lord.
to issue rule and we'll call for all records and we'll hear it, because your grievance is that the pension has been fixed at a rate which is incorrect, according to you.
Yes, my lord.
That is your case.
Yes, my lord. Pension, as soon as the provisional pension, I am going to, I will accept no, then my subsequent pensionary benefits will be reduced. If I will accept the provisional pension as a regular pension. It is not correct because my lord, as per ROP rules, my last basic pay, 50% of the last basic pay, that should be calculated. They have not calculated.
We'll examine that.
And that is to be decided, my lord.
Something else.
That is a very important point to be considered. My respectful submission.
Yes, we'll hear you, but on some other date. Not today.
Now, in the meantime, provisional pension will be.
No, you are not entitled to provisional pension if the PPO is there.
Yes. No.
PPO has been released. How are you entitled to provisional pension now?
No, people, my lord,
That's what he submits.
PPU, my lord, already we have challenged this, my lord, 7 and 8.
You may challenge it, that's a different issue. But provisional pension you are entitled to when your final pension is not worked out.
Yes.
My lord, in this case, my lord, no,
Once the PPO is issued, your final pension is worked out.
we have not received PPO, my lord. We have not received.
That is what.
My lord, at least
filed
provisional
an
pension will continue.
I have by affidavit. I
They
have
brought on
brought
record.
that page number 331. On my affidavit, my lord.
My lord, as per Rule 22 of the Assam Pensionary Rules, provisional pension should be continued till the date of receiving my regular monthly pension. And it is under process now. It is now under scrutiny, my
Where is
lord.
that affidavit? My affidavit, my lord. Yes. My affidavit, your lordship will.
At least my
Lord, that is my lord. By sign number one Sanjay Kumar Sinha, that is now deputy accountant, that is page starts from my lord here. It will be T23 million. Can we have the date? Date.
38 to
31 million. 5th of August. No. That was PP, huh? Sanjay Kumar Sinha.
Yes.
Yes, yes. Which paragraph? Paragraph? Huh? Which paragraph? I'll tell you. This paragraph, my lord, lordship. Paragraph 4. Yes, my lord. Mr. Sharma, please come to paragraph 4 of the affidavit. Which supporting document?
Paragraph 4.
Page 344 in our copy. It could be 326 in your copy.
Yes.
Document 331.
My lord, in our reason that I have given the answer, my lord. Page number 337. About the paragraph 4. With regard to SM is strongly denied by the answer. The petitioner submits the impugned PPO
Nothing
number.
to do with the pension. Nothing is mentioned here.
My
In your
lord,
rejoinder.
my lord, I have challenged this PPO. I have challenged this PPO.
You have challenged, it's a different issue that does not entitle you to get provisional pension because you have challenged it. That's contrary to the rules.
No, provisional pension, my lord, annexure 2 of the condemned case, as per order of the judgment of the honorable court, they have released.
You are agreed by the rate at which the PPO is the pension is
My
calculated.
lord, whenever I have challenged this PPO in this case.
We'll decide it.
Yes,
your
that
submission
should
before
be
the
decided, my lord, whether actually their PPO is correct or not.
All right.
Now, till then, my lord, at least the amount which has been paid, that will be released. Because how the family is going on, my lord.
Mr.
At least by respectful service, they may continue it till the death of.
Accountant General, Mr. R. Gopal for PHE.
PHA lordship.
Petitioner is aggrieved by the finalization, by the rate of finalization of the pension. Which the petitioner claims is calculated on the incorrect rate by the authorities concerned. We agree with present. Things are required. Actually require some here. Should call for the report. In the month of December.
My lord, December, no, actually, I will.
January.
I will go to Delhi on 10th, January 1st week.
January 1st week.
For
January 1st week, so we'll have it on the third week.
Yes.
Least on 20 January, 20. Yes.
In the meantime, my lord, provisional pension.
That we cannot grant in view of the PPO.
Yes, my lord.
Once we set aside the PPO, we direct them, then we may grant it.
Yes.
But once the PPO is there, is on record, unless we come to a finding that the PPO is incorrectly issued.
My lord, one thing.
There is no question of interference. You are claiming a higher rate, we'll examine that. But that does not mean that we'll grant you provisional pension.
PPO is completely irregular, illegally done.
We'll examine that.
Completely illegal. I want to not yet. I'll satisfy your lords. I'll satisfy.
Yes. 10:13. Yes.
My lord, I have filed my additional affidavit along with reply, but however, it's not in the record. I pray that maybe heard some other day along with the records of affidavit.
You have received copies?
I have received.
Counsel for the petitioner submits that affidavit in reply has been filed.
Additional affidavit.
Along with additional.
Along with additional affidavit in, along with additional affidavits of the same, however, are not connected to the case reports. Registry to trace out the same and list the.
In this case, well, I have appeared for resolution number 4. I have not received the copy of the affidavit.
After,
This matter may kindly be fixed in the month of January.
weeks. Mr. S.
For hearing, I have
submits that
already
he is hearing for respondent number 3.
No, 1, 2, and 3 I am appearing.
Who's your appearing?
I am the foreman, resolution number 4.
Respondent 4. He submits that copies of the pleadings filed by the petitioner have not been received. Counsel for petitioner will ensure service of copies on all respondent counsel. Yes.
My lord, interim may continue. Interim may be continued.
Interim order passed earlier will continue. List on 27th.
27th of January.
No,
You are not there.
November, my lord. November of this month?
November.
But respondent government has not furnished copy of the affidavit till today.
No, he is the respondent, my lord.
I am the respondent 4.
Give him a copy.
My lord.
Why are you not circulating copies? It's required under the High Court rules.
A copy should be furnished.
Give him a copy.
My lord.
Public.
Ablash.
Supplementary list for admission item 19.
Yes, Your Lordship. Lordship has heard this matter day before yesterday. The matter pertains to the wrong entry by the petitioner in respect of her category. She selected Gujarat Right category, whereas she belongs to.
What instructions have you got?
Not instruction, Lordship.
I placed this judgment of the Apex Court. Lordship has
Ah.
asked the respondent side to.
Yes, Lordship, I have seen the judgment. The
What do you say?
kindly come to para 10, Lordship.
Yes.
The question that arises for consideration is whether the error committed in the application form, which was uploaded, is a material error or a trivial error, and was the state justified in declaring the appellant as having failed on account of the same. And next, 11, admittedly, the appellant derived no advantage as even if either of the dates were taken, he was eligible. The error also had no bearing on the selection, and the appellant himself being oblivious of the error produced the educational certificate which reflect his correct date of birth. In this matter, Lordship, a petitioner wrongly filled his date of birth, and at the time of document verification, he proved his date of birth by producing supportive document as birth certificate and HLC admit card. But in the present writ petition, Lordship, petitioner made mistake several times, Lordship. At first, he feel that he was from unreserved category. And after that, there was no question of to produce his OBC certificate, Lordship. OBC certificate has not produced at the time of document verification, Lordship.
OBC not produced.
He feel as a unreserved category, Lordship. He mistakes several times, Lordship, make mistake. At first, he submitted as unreserved candidate. And in our advertisement, Lordship, it is clearly mentioned that it had been submitted with carefully. And after if mistake committed, then within 3 days, correction windows are open, and he have to correct his application. And he does not do so, and OBC certificate also not produced because he's submitted application as unreserved category, Lordship.
Lordship, here in this case, the petitioner had qualified all the stages of recruitment. The written test,
PET is
computer-based examination, PST and PET. May I take your Lordship to page number 66 for a minute?
verification with many candidates are rejected, Lordship.
Lordship, my learned friend has submitted that no OBC certificate was produced at the time of the document verification. May I take your Lordship to page 66 for a moment? The candidates who are qualified in the combined competitive exam, computer-based test and in the PST and PET, they are not required to submit a OBC certificate. The respondent provides a format of a OBC certificate which has to be signed by the district magistrate of the concerned district. That your Lordship will find at page 66. That certificate was produced at the time of after qualifying the PST and PET when the detailed medical examination was conducted. She submitted the format. Submitted the certificate as per the format prescribed by the respondent.
And regarding that OBC certificate, Lordship, kindly come to page 25 of the writ petition, Lordship. 6.3. For submitting OBC certificate, crucial date for claiming SC, ST, OBC and EWS status will be the closing date of receipt of online application. And his receipt online application was.
The case you're referring to and the case on facts are different. Your case.
I agree.
The case in which that was a
Date of birth.
Date of birth, Lordship.
1 digit.
Yes.
In your case, there are more than one error. Firstly, the benefit. Secondly, the caste certificate. How can you say these are trivial errors?
Because of the fact that in that case, if I take your Lordship to para number 14 of the judgment,
Lordship, whether at the same time, I'll take your Lordship to page 41 of the
You
writ
first
petition.
come to page 4, para 4. Last 3-4 lines. The bottom.
Page 4.
His case was that.
I agree. I will take, Lordship, may kindly see page 41 for a moment.
41 of
41 of the writ petition. Whether it's a misconduct. Because the advertisement says, page 41, serial number 16. Lordship. May I read, Lordship? Action against candidates found guilty of misconduct. 16(1) suspected and mismatched candidates. Candidates whose date of birth, districts, domiciles, name of parents do not match with the application submitted online. They will be categorized as mismatched candidates. Candidates whose LTI, signature, handwriting, and photo, and one of these do not match with the biometric data collected during CBE and online application, or do not match at any stage, they will be categorized as suspected candidates. 16.2, your Lordship will find, if candidates are found to indulge at any stage in any of the malpractices listed below during the conduct of examination or thereafter, their candidature for this examination will be cancelled and they will be debarred from the examinations of the commission for the period mentioned below. Now, on the next page, your Lordship will find serial number 5, making statements which are incorrect or false, suppressing material information, submitting fabricated documents, etc. Only this category is provided in respect of if someone makes a false statement. Here, assuming that the petitioner made a false statement, but 16.3 at the, has your Lordship got 16.3?
16.3.
16.3.
Yes.
Below the list. The commission may also report the matter to police investigating agencies as deemed fit. Further, the commission may also take appropriate action to get the matter examined by the concerned authorities, forensic experts. Now, in fact, the state respondents also, Lordship, they have also admitted that this is not a misconduct because no action after this was by the respondents were taken by the respondents, Lordship. Because now I'll take your Lordship to para number 14 of the judgment. May I read para number 14, Lordship?
Yes.
We are not impressed with the argument of the state that the error was so grave as to constitute wrong or misleading information. We say, on the peculiar facts and circumstances of this case, even the state has not chosen to resort to any criminal action, clearly implying that even they did not consider this error as having fallen foul of the following clause in the advertisement. Instruction to fill online application form are available on the website. It is recommended to all the candidates to carefully read the instructions before filling the online application form and kindly fill the appropriate response in the following tabs. In case the information given by the candidates found wrong or misleading, the application form will get rejected and necessary criminal actions will be taken against this candidate. Now, in this case also, Lordship, no action was taken by the state respondent. So therefore, the state respondent also agree that this is not a misconduct.
That is different, Lordship. That is as regard misconducts. And come to page 25, Lordship, of the writ petition. 6.1. Candidates who wish to be considered against reserved vacancies or age relaxations are required to submit requisite certificate from the competent authority in the prescribed format when such certificate are sought by concerned CCAFs for document verification at the time of DME. Otherwise, their claims of SC, ST, OBC, EWS category will not be entertained and their candidature applicable will be considered under unreserved category. Further, if a candidate has sought any other age relaxation or claimed ESM status and is not able to produce the relevant certificate, he will be considered in his respective category, that is SC, ST, OBC, EWS, unreserved, etc. The formats of the certificates are annexed with the notice examination. He have to produce his certificate, Lordship. But he cannot be does not produce the certificate, and even he was applied as unreserved category, Lordship. Therefore, he has.
There are other judgments contrary to this.
No, I understand. 6.1 clearly specifies that you have to produce a prescribed format to claim your category.
All right,
6.
we'll carry next week because we'll have to rise now. Third council for parties list again.
On Monday, Lordship.
Oh, Lordship.
Monday.
Let's have it on 12th.
Lordship.
12th November. What did you? Interview.
Oh, let's go.
May it be possible on 19, Lordship?
19.
Yes, Lordship.